For what?
for admission.
Monday?
Market.
This object, I did to mention for extreme RSM. Can we discuss the
For what?
thus
Why?
that was thus discussed from 18/7/22 till today.
Why?
We are for responding
Of which year?
2022. 2022.
Has the appeal been admitted?
In 18 July 22 petitioner file they did not file I.
I for what? Find out everything and mention it tomorrow.
Number 17 Lordship. I have taken consent from the other person. And the adjust 1717. 17 Lordship.
We'll see. We'll see later. I don't think it will reach.
There's a amicable settlement is going on, Lordship.
Fantastic.
Some process of settlement, Lordship, going on, Lordship.
When amicable settlement happens, very good.
Lordship, 2 weeks time,
We'll see when the matter reaches. It won't reach. I have a lot of other matters.
Top of the list, item 1.
Yes.
Last time you have heard the matter at some length, and then on 18th of March 2025, was pleased to frame another substantive question. And that is whether the learned proofs below were justified in declaring the suit in favor of the plaintiff, when it was an admitted fact that the plaintiff had duly executed the deeds specifically describing the plaintiff for, and the grievance of the plaintiff could have been taken care of by the provisions of section 55(4)(b) of the Transfer of Property Act.
It was only the question of 40 or 80,000 not being paid.
Yes. Yes, that is one part. And the other part is, my lord, the agreement for sale was in favor of sets of persons who are carried as defendants. For the second set, my lord, also gift deed was executed, and the plaintiff in his cross-examination admits that yes, I am aware that in respect of other defendants in whose favor I have executed gift deed, I have not challenged because I have got the full amount of consideration. And so far as these persons are concerned, he has not received the full amount of consideration money. That is why he is challenging. Well, my first submission will be, I'll come to this substantive statement moment, that this he has filed challenging the validity of the gift deed on the ground that fraud has been committed on him. Also, simply on the ground that he himself says that in respect of others, also gift deed has been executed, whereas he has further said that they are not my relatives. Although it is mentioned there out of love and affection, they are not my relatives. They are prostrated, but I have executed gift deed. I got no objection. I think the position where the question of fraud will not arise in my knowledge. And so far as his claim for the remaining part of the consideration amount is concerned, as your office has already framed this manner. Section 55(4)(b), I'll put the judgment directed side. 55(4)(b), before my friend replies. Notice 1999, volume 3, page 57. 57. The fifth paragraph, ultimately, it is para 36.
Yeah.
36. The definition indicates that 54 has been quoted just above that. The definition indicates that in order to constitute a sale, there must be a transfer of ownership from one person to another, that is, transfer of all rights and interests in the properties which are possessed by that person are transferred by him to another person. The transferor cannot retain any part of his interest or right in that property, or else it would not be a sale. The definition further says that the transfer of ownership has to be for a price paid or promised, or part paid and part promised. Price does constitute an essential ingredient of the transaction of sale. The words price paid or promised or part paid and part promised indicate that actual payment of the whole of the price at the time of execution of sale deed is not a sine qua non the completion of the sale. Even if the whole of the price is not paid, but the document is executed and thereafter registered, if the property is of the value of more than 100, the sale will be complete. There is a catena of decisions of the various high courts in which it has been held that even if the whole of the price is not paid, the transaction of sale will take effect and the title would pass under that transaction. To cite only a few, in Gayatri Prasad versus Board of Revenue, it was held that non-payment of a portion of the sale price would not affect validity of sale. It was observed that part payment of consideration by the vendee itself proved the intention to pay the remaining amount of the sale price. The same effect is the decision of Madhya Pradesh High Court in so and so. The real test is the intention of the parties. In order to constitute a sale, the parties must intend to transfer the ownership of the property, and they must also intend that the price will be paid either in present or in future. The intention to be gathered from the reciting the sale deed, the conduct of the parties, and the evidence on record. Applying these principles to the instant case, it will be seen that the defendant number 2 executed a sale deed in favor of the plaintiff presented it for rejection, admitted this execution before the sub-register, before whom the remaining part of the sale was paid, and thereafter the document was registered. The rest of this paragraph we can skip. Kindly come to paragraph 14. The judgment of the High Court on this point is also erroneous for the reason that it totally ignored the provisions contained in Section 55(4)(b) of the Transfer of Property Act, which are set out below. Only B is just below and the reading, where the ownership of the property has passed to the buyer before the payment of the whole of the purchased money to a charge upon the property in the hands of the buyer, any transferring without consideration or any transferring with notice of the non-payment for the amount of the purchase money or any part thereof remaining unpaid, and for interest on such amount or part payment from the date on which possession has been delivered. Clause B extracted above provides that where ownership of the property is transferred to the buyer before payment of the whole of the sale price, the vendor is entitled to a charge on that property for the amount of the sale price as also for interest thereof from the date of delivery of the possession. Originally, there was no provision with regard to the date from which interest would be payable on amount of unpaid purchase money. The special committee which suggested an amendment in this section gave the following reason. This clause is also salient as to the date from which the interest on the unpaid purchase money should run. It seems fair that it should run from the date when the buyer is in possession. It was on the recommendation of the special committee that the words from the date on which possession has been delivered were inserted in this clause by Section 17 of the Transfer of Property Amendment Act 1929. This clause obviously applies to the situation where the ownership is in the property was passed to the buyer before the whole of the purchase money was paid to the seller or the vendor. What is contained in this clause is based on the English doctrine of equitable lien as propounded by Baron Rolfe in the Court versus Burton. This clause confers statutory recognition on the English doctrine of equitable lien. As pointed out by the Privy Council in Webb versus Spencer, the statutory charge under this paragraph is inflexible. The charge does not entitle the seller to retain possession of the property as against the buyer, but it positively gives him a right to enforce the charge by suit. In view of the above, the High Court was wholly in error in coming to the conclusion that there was no sale, as only a sum of 500 was paid to the defendant number 2, and the balance amount of 4,500 was not paid. If the title in the property had already passed, even if the balance amount of the sale price was not paid, the sale would not become invalid. The property sold would stand transferred to the buyer subject to the statutory charge for the unpaid part of the sale price. Then para 47 of kindly. The proviso to the clause added by section 19 of the Transfer of Property Amendment Act 1929. The proviso also introduced in the clause only to set address the controversy about the nature of the document, whether transaction will be a sale or a mortgage. In this case, it was a mortgage by conditional sale. It has been specifically provided by the amendment that document should not be treated as mortgage unless the condition of repurchase was contained in the same document. The basic principle is that the form of transaction is not the final test, and the true test is the intention of the parties in entering into the transaction. If the intention of the parties was that the transfer was by way of security, it would be a mortgage. There are 49. The contents of the document have already been considered above, which indicate that defendant number 2 had executed a mortgage by conditional sale in favor of defendant number 1. He had promised to pay back rupees 1,500 to him by a particular date, failing which the document was to be treated as a sale. The intention of the parties is reflected in the contents of the document, which is desired as described as a mortgage by conditional sale. In the body of the document, the mortgage money has also been specified, having regard to the circumstances of this case, as also the fact that the condition of repurchase is contained in the same document by which the mortgage was created in favor of one. The deed in question cannot be treated as a mortgage by condition. This is also the finding of the court. Well, I'm relying on the judgment to say that in this case, my lord, since the plea of fraud in execution of the gift deed false, because he himself says that I put no objection in the gift deed, and the agreement for sale he is not chilling. The advance amount he has taken, he is not chilling. Possession, admittedly, my lord, he himself has admitted that I am not a failed but to my man. In view of that, my lord, although the document was executed to be a gift deed, it is a transfer, a registered document, and its suit for cancellation of the gift deed will not be maintained. First submission. And for that, I'll be also relying on one judgment, the recent judgment. I will. I will. If I could print down. In 2025, 36351.
Just one.
Second, complete. Complete.
You have it?
I'll take from the tab. From the tab, I'll be the ICC on. Yes. Yeah. 51.
Yes. Paragraph.
Para 44. Para 44. Oh. Oh. मतलब 4 में
है ना?
para 44 में मैं read from para 40 में. Having held thus, allowing the inevitable result. However, before we part, there seems to be a discordant note struck by the decision in A. Kanthamani while distinguishing I as Sikandar. B. Uncertainty and confusion. It is therefore considered worthwhile to attempt and clear the same. A comprehensive reading of the two decisions reveals that in a fact scenario where the vendor unilaterally cancels an agreement for sale, the vendee who is seeking specific performance of such agreement ought to seek declaratory relief, the fact that the cancellation is bad and not binding on the vendor. This is because an agreement which has been cancelled be rendered non-existent in the eye of law, and such a non-existent agreement could not possibly be enforced before a court of law. Both the decisions cited above are unanimous in their approval of such legal principle. However, as clarified in Kanthamani, it is imperative that an issue be framed with respect to maintainability of the suit on such ground before the court of first instance, as it is only when a finding on the issue of maintainability is rendered by the trial court that the same can be examined by the first or and second appellate court. In other words, if maintainability were not an issue before the trial court and the appellate court, a suit cannot be dismissed as not maintainable. This is what Kanthamani holds. The aforesaid decisions of this court expressed by coordinate benches demands deference. However, it is noticed that this court in Kanthamani had not addressed on the effect of non-existence of a jurisdictional fact. The existence thereof would throw the trial court to try and consider granting relief. That is, what would be its effect on the right to relief claimed by the plaintiff in a suit for specific performance of contract. In Srisht Dhawan versus Shaw Rose, an interesting discussion on jurisdictional fact is found in the concurring opinion of Honorable Justice R.N. Sahai, as is Lordship 10-1. There are 19. What then is an error in respect of jurisdictional fact? A jurisdictional fact is one on existence or non-existence of which depends assumption or refusal to assume jurisdiction by a court, tribunal, or an authority. In Black's Law Dictionary, it is explained as a fact which must exist before a court can properly assume jurisdiction of a particular case. Mistake of fact in relation to jurisdiction is an error of jurisdictional fact. No statutory authority or tribunal can assume jurisdiction in respect of subject matter which the statute does not confer on it, and it by decisively deciding erroneously the fact on which jurisdiction depends, the court or tribunal decide the jurisdiction. Then the order is
Mr. Mudinda, why are you relying on this?
I am not relying on this judgment because in this case, what happened? It was a suit for specific purpose of contract. The agreement was cancelled by the vendor. And the question came, if the agreement was cancelled without praying for a decree, declaratory decree that the cancellation is bad, this suit will not lie. This plea was not taken, and then the question arose: if the plea is not taken, it should go back to the trial court. Argument was, as you also in para 41, argument was that it should go back to the trial court. Then so all no. The superior courts like High Court or Supreme Court will dismiss the suit if the suit is otherwise not continued, even if the plea is not taken, even if no issue is framed. On that, for that matter, I'm relying.
How does this have any relevance?
Because in this case, if although they are filing, they are filing for declaration that is if it is bad on the ground that fraud was committed. Now I'm sure, my lord, I'm further submitting that in view of the admissions made in the cross examination and other relevant facts, it is clear now that execution of gift deed was not a fraudulent act. He himself has signed the document His signature is there, he's not disputing. It was a registered document. In view of that, my lord, and in terms of the judgment which I have read in 1990, that India, that's case of 1990, his only claim he may have is to recover the remaining part of the consideration money. And a suit for declaration that the debt is bad will not be maintainable, my lord. It's my humble subject to lot of consideration. Why? It will not be maintainable because fraud has not been able to prove. It
That is another thing.
Right.
When he proves fraud or not, that is another aspect.
Right.
But how does this judgment help you?
Well, that's why I'm saying, if he fails to, if he succeeds in proving fraud, then matter will be different. If he fails to prove fraud, then what remains is, it should be considered to be a document of sale. That's my humble suggestion to your lot. Because he has received admittedly he has received the advanced amount. Admittedly, the agreement for sale is still in existence, not under challenge.
An agreement for sale is as per section 54.
Right.
It's only a contract for sale,
Right.
for which there is no
Well,
right.
that submission I'm making show that his intention, his conduct and his intention.
Because here the case is, in the judgment you are referring is in respect of a person concerned having already made, cancelled an agreement for sale.
Well,
And there being no challenge to that agreement, for
Yes.
say cancellation.
Yes.
He cannot maintain a suit for specific purpose.
Yes.
There's no quarrel with that proposition. I don't need that so much of the thing was to be written also. But the question is, how does this have any relevance, taking into account the agreement for sale is still in existence?
Right.
But if the agreement for sale is still in existence, it is only an agreement by which you can get another deed
by its specific.
as per the provides.
Right.
It's only another deed to it. So therefore, how does that help you out here?
This judgment I am saying for a very limited purpose, that in view of the fact that fraud has not been, he has not been able to prove the fraud, then the suit for declaration that if it is bad will not be maintained.
That is another thing.
For that only I am lying.
But that is okay.
Because otherwise, we have not taken a specific plea that suit is not maintainable. That is why I am relying on the judgment. It's
No,
very
whether
bad.
you take the plea of maintainability or not, that is immaterial.
Right.
The question is, if he has not been able to prove fraud,
Right.
raise the document normally stands.
Fine.
Then. But the only thing which needs to be there, submitted before this one, is how do we change the nomenclature from a sale deed to
15 to say.
deed to sale
My
deed?
lord, this is one area where we have to, my lord.
How do we do that? Because that is a very important aspect.
Right. Absolutely.
If I
Doctor is absolutely correct here.
I bring it, there's no quarrel with that,
Right.
if I forbid, I'll bring it. But how do I change it? Yes, there are many judgments. In fact, a recent judgment on the power of attorney has also said.
Yeah.
What is there in the name?
Sure.
There's nothing in the name, but it is so. But the Transfer of Property Act specifically deals with the sale with differently from a deed or gift. Now, how do you convert
My lord,
a gift?
it is in response to this plea which ultimately will come as well, just calling from the law here, that I'm relying on the judgment to say that because possibly matter subject to further discussion and possibly what will. And it may be difficult to say that it is a sale. It may be difficult, subject to what we are looking at, what you're also. It may be difficult to hold that, although it is retail, but it is in fact a sale. Although
No, but there can be another aspect which can be seen from the 99 judgment. From the evidence of the parties, including the agreement for sale, it was all along the intention to have a sale.
exactly,
So under such circumstances, if it is a sale deed, so can we name it with agreement for sale? Because you, on the one hand, have already stated in your evidence that you have paid that 40,000.
yes, remaining part also I agree.
You have said that you have
Right.
paid that 40.
Yeah.
Now the question is, you have failed to prove that aspect.
Fine, according to the finding, but it was.
Findings, and that finding, I cannot touch it. Taking into
Fine,
account, there
fine.
seems to be no perversity in that. So the fact remains that you are therefore to pay that.
Fine.
Now, how do I bring in 55(4)(b) into a giftee and making it or changing the nomenclature from a gift to a sale deal? Is the question where
Absolutely. The court is absolutely correct. That there the whole difficulty lies in this. Because ultimately, unless the document is
have you seen the recent judgment of Justice Patiwala on the power of attorney? The very recent judgment on the power of attorney. So there, it's a very interesting case. Although it's a very lengthy one, but the fact remains that a person concerned had executed a power of attorney unregistered in favor of somebody. And that person concerned, after his death, transfers his property to his son. Now, there has been a challenge to this that there cannot be anything. In simple language, the case is unless you have a registered power of attorney, you cannot execute a registered property. Rather instead. But the Supreme Court went further as regards what is a general power of attorney, what is an irrevocable power of attorney, whether you mention it out there or not, that is immaterial. You have to see the intention of the parties, which can also be seen from the 99 judgment also. But you have to give me a way by which I can convert this sale deed into a gift deed, or the gift deed into a sale deed, whatever name may be, and I do so. And then imply 54(5).
because your order is correct, right? In order to apply 55(4)(d), the document has to be for the sale. And that is why
If it is a sale, then in that regard, how do I do it? Because that is the only problem I find out there.
absolutely that is the only issue here. Because otherwise, my lord, it is a sale for all practical purposes for the simple reason that he has not seen that the agreement is bad. He
It transfer to. So let us see.
Fine.
The
his
difference
right,
between the
vendor's right is 5.
The difference between a gift and the sale, 21 will be. If is a transfer of title existing movable unit voluntarily without consideration and by one person owning the donor to another, or the accepted by with acceptance with the action right to the acceptance. Now, in a case where a transfer is effected, a gift is effected by way of a for consideration. Let us take an example. A gift is effected by way of a consideration which does not fall within the ambit of the definition of section 22. Then in that case, can I convert it into a sale? I think we will find out judgments on this one.
One judgment in when I was searching, I got where the it would say even in a gift deed, there is a consideration. Consideration is the law benefits.
That is another.
Another
Now, let us take the example that if in a gift deed, there is a mention of a consideration, an amount that I've got some, there might be,
yes,
so it may not be there, there are a lot of things. There might be a gift to the effect that I am going to give that particular, if you give me I'm gifting it because he has given me this other plot of land. That might be also, there might have, I've seen in trial court, there are many cases to that effect. So it may not be a gift per se, in terms of section of 122. But if it is not a gift, can we say it to be a sale? as there is a consideration, because if you see the definition of 54, is a transfer of ownership in exchange for a price paid or paid, a price paid or promise or part paid and part promise. So if that be so, whether the nomenclature of it to be a gift, and when the pleadings itself say that I was about to sell it to him, and I have duly executed the document as a sale, but he has made it, shown it to be a gift, not to give me 40,000.
Exactly.
This is his pleadings.
One line. And I'm getting.
That is his pleadings,
That
if
is
I
his
remember correctly. So then can this court say that in fact this was never a gift, but it was a sale?
I think it's almost can, because particularly when it is facts of the present case, madam, is that that's why I'm repeating, madam. There is an agreement to sell. Till now,
So Majumdar, you have to tell me. Normally I will take my endeavor to do it by myself. But
I will.
with two stalwart senior advocates standing in front of
My
me,
lord,
I would definitely
No, I'll-
take up that.
I'll make some more.
my lord,
appeal.
I am enlightened by your lordship and my friend. I have put in almost 31 years of practice. And this is the first case where I am arguing a second appeal, that too on a substantial question of law. I know your lordship expert on the civil side and my friend. So my endeavor is that first I should learn from your lordship, then I will try to address your lordship. I'm not a stalwart, so for second appeal is concerned.
Madam, my view is I am learning every moment. I'll learn something from him also in this.
And I'm not looking at
Therefore, the question is, how do I change it?
Madam, I got.
I can, with different thing, I can very well find it out and do it. There's no problem with that. But why should I think about that?
Madam, I'll some.
But this is the interesting point which
Very
has
interesting.
come in.
I was reading
Because-
the judgments, I was finding a lot of interest, particularly the other matter, 1993.
Because this is an important point. A lot of people don't think about 55 4B.
Already.
Normally, because nobody thinks about 55 4B. That it is a charge only being created,
Yeah.
nothing more than that.
And this 1993 and there is one judgment, more judgment says that both the parties, vendor also has and the buyer also has a charge. To the extent he has paid. And what is the meaning of this advance amount he has paid? What is the meaning of the initial payment made? So you lot some more time and some more entry.
End of that aspect, how do I do it? By taking into account the intention of the party, how the intention of the party is.
Exactly.
And therefore, if I have to allow your fee, there has to be the payment of that along with interest.
With interest.
With interest that has to be
Right.
paid. Now, in that regard, can this court do so? Without there being a suit, taking into account the
Why not?
observations made in Sagir Ahmed
Why not?
by Justice Sagir
Why
Ahmed.
not possibly can do it because instead of passing a decree saying that you also can make an observation that is entitled to this. That observation in the form of an observation can always indicate.
Then I exercise order 41 with 33.
What will be 1 week time? But I found it very interesting. The lordship has shown the way by referring to 55 40 now I'm
Because the earlier substantial questions of law. But while I was staying in Kohima, one thing, there was always a point, what is happening out there in the trial courts. And the recent judgment of the Supreme Court to complete the execution proceedings within 6 months. I could see there is a mistake being committed. Now, I have passed one judgment on the trial, wherein I said that you have to fix a date for hearing of the suit. And then the three adjournments will be counted accordingly. See how it is. Because that is the mandate of the CPC. Now, in execution also, there is a requirement. But we don't see that taking into account that Order 21, Rule 105 and 106 is put in such a manner, it is seen that it is being brought in the fold of Order 21, Rule 97 to 100. But 105 and 106 were brought in by the 1976 amendment also, like Order 21, Rule 97 to 104. But while bringing in, these are two different sections. One is section 72 and one is 73. Section 73 brings in 105 and 106. Then Kohima, you get a lot of time. So I was further making searches out there and I could find that a Law Commission report in 1964 says one thing, that Order 9 does not apply to execution proceedings. And therefore, the question of dismissing for default when execution proceedings could not have been done in here without Order 9, because Order 9 categorically mentions that it shall not apply. So therefore, it was the requirement which was made, recommendation made in 1964 Law Commission. Then comes the 1973 Law Commission report, which further endorses that these are the things which are required to be. But while bringing in, they did not mention a separate column. Like if you see, the chapter under Order 21 from 97 starts with obstruction.
Yes, sir.
Okay,
Exactly.
but it continues with 105 and 106, which should have been separately put as miscellaneous or something. And having not been put, this is not the thing which is being looked at. Now, there is a very interesting thing out there. It also says that the court will, if you see Order 21 Rule 23, one says the court will going to fix a date for hearing. And if the person is not present or does not file an objection, the court is going to pass an order under Order 21 Rule 23 too. Now, there are certain judgments of other high courts which say that it falls within the same ambit of Order 21 Rule 197 only. But taking into account the Law Commission's report and why 105 and 106, I think those judgments of the, with due respect to the other high courts, may not be proper. And more particularly, when Order 21 Rule 105.2 refers to Order 21 Rule 23, otherwise it would have referred to Order 21 Rule 101, which has not been done. So therefore, here also there is a question of fixing a date for hearing in an execution proceeding, which is not being done. And if it is a date for hearing is being fixed, then you can take it and bring it within the ambit of 6 months.
Ultimately, in execution proceeding, in execution proceeding, it's not a
Now, this is, you can do so by fixing a date for hearing. If you see the CPC 105, Order 21 Rule 105.
hearing of a thing.
So actually, it should have been, and if you see this along with Order 21 Rule 23.
Procedure after issue of notice, where the person to whom notice does not appear or does not prove of this expression before why they decree the order they decree the decree,
And see number 2,
where such person offers any objection to the execution of the decree, who shall consider such objection and make such order a decree.
now kindly come to Order 21 Rule 105.2.
Where on the day fixed or on any other date, the hearing may be adjourned. Applicant doesn't appear when the case is called on for hearing, they make an order that the
So this is first. Number two is,
next one, number three, where the applicant appears, the opposite party informs the notice that the issue by the court does not appear. The court may hear the application ex parte and pass such order as
and then 106(1) three,
6(1) setting aside orders passed ex parte, etc. The applicant against whom an order is made under subgroup 4 of Rule 105, or the opposite party against whom an order is passed ex parte under subgroup 3 of that rule, or under subgroup 1 of Rule 23, may apply to set aside the order, and if he satisfies the court that there was sufficient cause for his non-appearance, whom they was called on for hearing, the court shall set aside the order for on such terms as course or otherwise and shall appoint a day for further hearing.
now again, you see the next provision, 106(2), I think.
Yes. No order shall be made on an application by subgroup 1 unless notice of the application is served on the other part.
I think 3.
B. An application under subgroup 1 shall be made within 30 days from the date of the order, or where in the case of an ex parte order, the notice was not duly served within 30 days from the date on when applicant had knowledge of the order.
So the limitation is being said at 30 days. Now, section 5 does not apply because section 5 takes away the applications under the execution. So say you can't bring in section 5. So this is, I think, the only way by which you can complete it by directly fixing a date for hearing.
The minor fix.
And that is what, how do you do it? Because otherwise execution goes on and on and on and on. And the reason why people say that execution takes a time, but if you see the CPC properly, the CPC provides all remedies and therefore limits it to 30 days. It is dismissed for default 30 days, nothing more than that. The hearing remains incomplete. It is the matter again next week.
Next week only minor, I will be not Monday and Tuesday. Monday and Tuesday, I'm not just any day. Other than Monday.
On 6th of May. 6th. But the hearing at the top of the list.
For motion item 2.
Yes, what is this? What are you challenging?
It's challenging to file the application on the order 23 lawsuits
For that?
for withdrawal of my suit lawsuit.
Ah.
They are for refiling the press.
Hmm.
Imping order is at page 31. My application is at page 26.
Rightly.
I got accidentally what happened lawsuits. Yeah, in case instead of purchasing the suit land, the state had claimed lawsuit. But
No,
lost it
Mr.
because it's
I'm
covered at
dismissing
the
it.
time of
You withdraw.
lost
I'm dismissing it.
with liberty lawsuit. I am
What liberty?
liberty press other my.
No. You see your application, page 26. Right, with no-
I have seen lawsuits.
No,
one judgment.
No.
I,
no judgment, nothing.
not,
When you are not giving any reason, why so?
not, to-
Rightly so, the lawyer was
nothing,
dismissed.
nothing stated.
Then-
Case lawsuits, even at the time of this, at the time of hearing, found that Supreme Court said lawsuit.
If you don't mention in your pleadings, then where is the question of the other side getting an opportunity? Tell me. No, I,
Lawsuits,
the learned counsel appearing on behalf of.
Supreme Court
the petitioner.
did not disclose that report, but
Which one do you want? Dismissal or which one? Which one? Go ahead, fight the litigation. Which one?
I'm allowed to.
Mr. F. U. Barbuya, the learned counsel appearing on behalf of the petitioner, it submits that you would not like to press the question for the stands closed and withdrawn.
Like. For at least an item for
Yes, Mr. Sahu.
I did. Undertaking. I have filed the undertaking on it. Yes, undertaking.
They filed the fresh undertaking. Hey, इतना आधा डिसीजन नहीं किए थे हाँ? I dictated something.
Yes, that madam was there. But yes, just I'll point this one thing, madam. Well, there was an agreement for sale in respect of 1/5 lesson. Out of that, madam, 19 lessons, 19 lessons sale deed was executed, and in respect of the other 9 lessons, madam, only agreement for sale was executed. So in respect of the agreement for sale part 9 lessons, madam, he has no right to interest. So he not be allowed to construct on that plot of land. Even if an undertaking is made. Because sale deed is there only in respect of minor 16 lesser.
But you have challenged the sale deed,
My lord,
both the sale deed also.
sale deed.
You have challenged the sale deed.
At page number 22.
But what right does he? He may have right under 53A.
53 is number.
Then construct, you take over. Build the construct. Where's that undertaking?
Or 28, 25 minus 10. On 10, 4 we got. 10. This one is on 10, 14.
Potentially construction made in the independency of this. Is that order, judgment?
Reported. 25 1. Para 6.
Where is that order? But Mr. S. Sahu, the learned counsel appearing. Petitioner, petitioners. Petitioners. But the learned counsel is bearing on behalf of the council. The supervisory jurisdiction of this court have been invoked. Challenge the order dated 16/11/2024, passed in Miss Appeal number 1/2023 by the court of the additional district judge Biswanath at Biswanath Sariali, hereinafter referred to as the first appellate court. Whereby there was a direction from the parties to maintain status quo. Till the disposal of the original suit, so that both the parties may abstain from making any construction of on construction over or possession. They abstain from making any construction or possession over the suit land. Mr. S. Sahu, the learned counsel, appearing on behalf of the petitioner, submitted that the petitioner number one has a registered deed of sale in his favor, in her favor, in respect to an area at measuring 16 lectures, 16. Schedule C. 16 lectures, which is specifically described in Schedule C to the plaintiff. And further, the petitioner number one enjoys rights under Section 53A over the land described in Schedule B to the plaintiff. He submitted that till the registered deeds of sale, registered deed of sale as well as the registered agreement for sale, on the basis of which the petitioners are in possession over the Schedule A land, are set aside in accordance with law. The learned trial court, at the learned first appellate court, ought to have appreciated that the balance of convenience was in favor of the petitioners to go ahead with the construction, in as much as stalling a construction which is almost to be complete, and without there being any bond or undertaking taken from the plaintiff, that the plaintiff would recompense the defendant, the plaintiff of the respondent herein, that they would recompense the plaintiff, the petitioner, in the eventuality the suit is dismissed. The question of grant of an injunction did not arise. The learned counsel further submitted that the petitioners herein are agreeable to give an undertaking that in the circumstance the petitioners are in the circumstance, the plaintiff oblique the respondent herein is in, he in a, gets a decree from the court, they would demolish the construction or hand over the constructed premises to the defendant without any further without any further decree to be passed by the learned trial court. To the plaintiff. The plaintiff. The learned counsel further submitted that an affidavit has been filed on 8th of April 2025 before this court by the petitioner jointly giving an undertaking I've also heard Mr. A. Iqbal, the learned counsel, appearing on behalf of the petitioner, on behalf of the respondent of the plaintiff, who submits that the deeds on the basis of which the registered deeds on the basis of which the plaintiff, the defendants, oblique the petitioners herein, have claimed right over the Schedule A land are fraudulent. And as such, no right whatsoever has accrued upon the petitioners over the land in question. He further submitted that in the circumstance any construction is carried out over the land, the petitioners would have, the plaintiff would have to seek a further decree for demolition of the said construction and at their own cost, the construction, which would cause further, which would cause irreparable loss to the plaintiff. This court has given anxious consideration to the above submissions made by the learned counsels appearing on behalf of the parties. And have also perused the claimed, the injunction application, as well as the written objection and the written statement filed by the parties before the learned trial court. This court have also perused the impugned order by which there is an order of status quo granted in respect to the construction to be as regards the construction. This court have further taken note of that the construction so carried out by the defendant plaintiff petitioners are at nearing completion. Nearing completion.
Most of the work.
Where have you mentioned? Forget about that. In the petition, have you mentioned it or not? Huh? Is it a fresh construction or new construction? Is it a fresh construction?
Prior to petition of food, there was contracted.
How much? You have taken permission? Have you taken permission for construction or not?
Yes.
Where is it?
That was not, you know, tightly.
Then? In the additional affidavit also you did not bring it.
Construction application at page 29 had stated that they have started construction from 8/3/2020.
From
8/3/2020.
23. And they have also taken note of that the petitioners herein have made some constructions over the suit premises, over the Schedule A land. And also, the said construction is half done. Additionally, there are building materials which are lying and would get damaged if in the circumstance the injunction order is not vacated. In addition to that, this court have also perused the affidavit so filed by the petitioner dated 8th of April 2025. And in the said affidavit, the petitioner had given an undertaking at paragraph number 3, which is reproduced herein under. Page 92. From the above undertaking, it would be seen that both the petitioners have undertaken to demolish any construction made over the disputed the suit land during the pendency of the suit and hand over the possession to the respondent plaintiff in the circumstance the respondent plaintiff succeeds in the proceedings initiated by them. In addition to that, the petitioners have also undertaken that they would not create any third-party right over the suit land during the pendency of the suit. The said undertaking, so given before this court by the petitioner, would be construed to be an undertaking given before this court. And any violation to the said undertaking at a later stage would amount to not only to taking various any violation to the said undertaking would be taken as violation would amount to giving a false undertaking before this court. This court, having taken into note of the said undertaking, is of the opinion that with the said undertaking, the balance of convenience shifted in not granting an injunction insofar as status quo as regards the construction. Taking into account the above, this court, therefore, modifies the order dated 16/11/2024 passed in Miss Appeal case number 1/2023 passed by the Learned First Appellate Court, that is the court of so and so. To the extent that there shall be no status quo as regards the construction over the supremacies over the Schedule A land. The said construction for made shall be subject to the outcome of the suit. Further to that, in the circumstance, the suit is decreed in favor of the plaintiff, comma, the defendants, oblique the petitioners herein, as per their undertaking, shall hand over the possession over the said constructed premises along with the land, along with the decreased Schedule A land to the plaintiff. Without any further decree, without the requirement of any additional decree from the learned trial court. This court further directs that both the parties shall maintain status quo over the suit premises as regards the title and possession with the disposal of the suit being title suit numbers. The above the instant proceedings.
If the order it is a substantial portion. Substantial portion of the ground floor was ordered.
For hearing. Chapter 41 rule to CPC. I can
By order be also placed before the learned trial, which shall be a part of the records of the learned trial court. And it's okay, not necessary, we will always be.
Yeah, bye.
Yes, Mutali.
Watch it. This case, what happened? We filed the suit, you know, it is very difficult, we are filed like. For calculation of a gift deed as well as the sale deed your lordship. Every ground by misleading the lordship. Those person that is different number one, offering my signatures on planned non-judicial purpose. And that has been converted into gift deed as well as your of the sale deed. Simple pair your lordship that these are not properly executed by the plaintiffs your lordship and particularly plaintiff number 5. So, Custodial is your lordship only one time. As against that your lordship, the defendants they have whether they have actually filed the written statement with a counter claim. Or 2 kotha 10 by 10 and 1/3 lesser euro. Our sublet is 1. So he has claimed your lordship this counter claim your lordship against some person who are defendant your lordship. The trial court your lord dismiss our suit that we failed to prove. But the counter claim has been your lordship, it has been allowed without the proof of the gift deed as well as the sale deed as contemplated under section 68 and 67 of the. Now, the counterclaim your lordship will file your lordship. So against defendant, how counterclaim can be given? That is one point your lordship. Secondly, your lordship, here
How are you concerned with the, you are not the defendants,
I played it.
then how are you concerned with them? They have to come before this court.
So
Are you, are you
Defendant-
putting the brief for them?
defendant counterclaim is against the defendant.
Understood, but why the other defendants are not coming?
But they are party good. They are party good.
So what? They are not coming before this court.
Anyway, your lordship, this cannot be granted.
That is not an issue. That has
Outside-
nothing to do with you. Your claim, your suit, who had filed the suit saying that the plaintiff have asked the defense plaintiff number 5 to take a loan from the State Bank of India. State Bank of India did not grant a loan. When the State Bank of India did not grant a loan, the plaintiff number 5 went to the defendant number 1. The defendant number 1, when you went out there, defendant number 1 said that, okay, I will give you the money, provided you sign these 2 documents. You sign some blank papers and non-judicial papers, and then no money was paid. Later on, you come to know that the defendant plaintiff number 1 to 4 have executed a deed of gift in favor of the plaintiff number 5, and the plaintiff number 5 executed a deed of gift, still a deed of sale in favor of the defendant number 1. That is your fact.
Correct. Correct.
So
Now your lordship will find,
when did you go and sign?
lordship, that is not here.
That is relevant.
That is
Relevant.
because the documents are with the defendant number 1. Your
So
Now,
when did you go? You would not, because this happened in 2007. You filed your police case in 2008. You didn't know
lordship,
what happened to the criminal case.
lordship, notice,
You have only adduced only the FIR.
lordship, not, I am not on that, your lordship. If there is a valid gift, whether there is a valid gift, whether there is a valid sale, and if that is valid, your lordship, it must be proved according to law. And that has not been proved, your either the sale deed or it is before. Now your lordship will come to the fair in the counter claim. In the counter claim, your lordship will find they have prayed for partition of the good land. But there is no preliminary decree. There is no, your lordship, specification of the respective shares, your lordship. That way, your lordship decree has been passed, that decree has paid for. If decree has paid for, your lordship, what is the decree has paid for, your lordship?
We'll make it clear.
Lordship, I'll be coming to the,
We'll
Outside
exercise
claim, your
order
lordship.
41 rule 33 and make it clear.
so that decree, ineffective decree, your lordship, that cannot be passed.
Well, you should be happy.
Lordship.
Go under 47.
So there is different thing, your lordship, for
Go under 47.
that ineffectivity or illegal decree.
Go
your
under
lordship, cannot
47.
be
Your
passed, your
basic question is forget about the counterclaim. What they are saying. How many appeals you are filing?
lordship.
Why you are filing 2 appeals? No, 1 appeal.
Lordship, we have challenged only the counter claim. Only the counter claim we have challenged.
So you are not challenging your decree.
Lordship.
Okay. So if you are not challenging your decree,
Right.
you are only challenging the counter.
So for, we are challenging the counter claim.
So therefore, the deed executed in favor of them is right. Of the defendant is right. The moment you are taking away your hand from that challenge, the deeds, the gift deed and the raise the sale deed is okay.
Lordship, that presumption cannot be done, your lordship.
The court has,
So, but the law is
it's a
concerned,
finding of fact right there.
whether that presumption cannot be taken, your lordship, when the law says something else, your lordship.
The law says
No, it-
something else. I have seen the
Let me-
judgment. The
me
judgment says
take
that the
one
trial court
decision.
judgment is self-explanatory, properly
Let me
done.
take one decision, your lordship, that is, thank you. Lordship, 2003, 1 SCC 197.
What does it say?
This is on, your lordship, the passing of decree, your lordship. And decree, your lordship, I'm reading para 10, your lordship. 11, 12.
2000?
2003, 1 SCC 197. There are 11, 12, your lordship. There are 11, 14, 15. So that decree, your lordship, is no decree in the eye of God. There are 11, your lordship.
You have no locus standi.
Right, 11 your lordship, it is important.
Yes, where is your citation? কি ইন্টারনেট কাম নকরেনি তো?
Your lordship, one second.
Yes. There are 11.
There are 10 and 11.
So we dismiss your appeal and grant the liberty to the respondent to file an application under 152 for correction.
Lordship, this matter may be, this matter may be your lordship. Remanded back to your.
No, actually,
Remanded back by
No.
your lordship. Lordship, so far this decision is concerned, your lordship. Decree must be effective. And non-effective decree cannot be passed by.
so therefore,
That is a waste.
no, this
that
can
is
be,
wastage of time.
no, Mr. Ali, this can be very well done in terms of paragraph 14 and 15. Or paragraph 14 and 15 of the said judgment, you have not read it. You have only read only on paragraph 11, 12.
Lordship, I'm reading just one sentence, that
You
judgment.
don't
has
read one
been-
sentence, Mr. Ali.
Para
Read
tell
the
your
entire
lordship,
one.
para tell your lordship, tell your lordship. Before
We
dismissing
dismiss
your
your
lordship.
appeal.
before
And
dismissing
direct,
your lordship,
and direct, and say that to the
yes,
client.
I may be hard, your lordship, I may be higher on the point, your lordship.
I've heard it. The thing is that,
Your-
first of all, you are not challenging your sale deeds. The give deed and the sale
We
deed
have
has
challenged-
been done.
And
Give deed
there is-
and sale
There
deed
is
have been
also
done.
no law, your lordship, that against a single decree, your lordship, judgment, your lordship, there should be two appeals. Counter claim, then another appeal, and if against this suit, your lordship, another appeal, your lordship. Supposing a judgment has been passed, your lordship, common judgment against the counter claim against the suit. So is there any law, your lordship, that there should be two appeals, your lordship? I don't find it in your lordship. I don't
First
find-
of all, counter claim will be treated as a claim in the suit.
Correct, your lordship. Correct.
So under such circumstances, it will be as if it is that two decrees are being passed by in one consolidated suit. It will be take the turn of Order 41, Rule 1, which categorically says that when there are two judgments, it can be consolidated and made one judgment also. And there can be two appeals. See order 41 rule 1.
Order for to say something, but will not to be
Read that. Order 41 rule 1.
appeal from original degree geology, original degree geology. Every appeal shall be prepared in the form of a memorandum signed by the applicant.
Kindly
Or
see the
is
proviso. See
and
the proviso. No, see the proviso. Provided that where there are two or more suits have been tried together and a common judgment has been delivered therefore and two or more appeals are filed against any decree covered by the AR, whether by the same appellant or by Iman, the appellant was may dispense with the filing of. So there are, when there is one suit, one decree, they you have to, because the plaint as per order 8 rule 6A, it is the requirement that there has, it is to be taken, the counterclaim is to be treated as a plaint.
anyway, your lordship.
Only way,
When-
there is no any way, there is only way. Only
Even
way is
because
to
your
dismiss
law
your
is-
appeal.
Law is not clear. Anyway, your lordship, law is not clear.
Not
It's a
clear, I make it
technical
clear.
point.
I make it clear.
So far, decree is concerned, it must be technical.
That if it is the mistake of the court, so therefore I grant the liberty, kindly see paragraph 15 of the said judgment. What did the High Court, the Supreme Court say? Granted liberty to under 152 to file an application for giving in terms with the judgment, the decree.
No, that 52 does not cover your lordship, this fact, your lordship, this is the new fact, your lordship, and it shall be decided afresh. It shall
No,
be
nothing
decided
is
afresh,
there,
your
nothing
lordship,
is there to decide.
Because-
afresh.
Because your lordship,
Okay, let me come back, I'll dictate. No, this type of appeals.
Your
can't be taken.
lordship, I am plaintiff, I have lost your lordship. It is admitted finally, your lordship.
No, you are not challenging that.
Now your lordship, another is.
You are not challenging that portion of it. You are challenging the counterclaim.
Your lordship, I am placing another decision, your lordship.
Please.
That is 2022 PSCC. Page 610. 2022 7 SCC. Page 1, your lordship.
Which one do you want? 2022,
Lordship, same judgment, in the civil, I have referred.
2022,
SCC, your lordship, 2022 7 SCC. 1, page 1, your lordship.
yes.
Lordship, 73, your lordship will find. The execution of a document does not stand admitted merely because a person admits to having signed a document. Such an interpretation accounts for information, the circumstances where an individual signs a blank paper and it is later converted into a different document, or when an individual is made to sign a document without fully understanding the content. Adopting a contrary interpretation would unfairly put the sudden burden upon the person denying the execution to challenge the registration before a civil court or a read court. Since registration will have to be allowed once the signature has been admitted. In giving meaning the expression for 74 year old execute in the provisions of registration act, it is necessary to adopt
Paragraph,
the purpose of constitution 74. Facilitate and achieve the object of registration, so. Registration provides safety and security to transactions relating to equitable property even if the document is lost or destroyed. It gives publicity, public exposure to document, thereby preventing forgery and frauds in regard to the transaction and execution of the document. Registration provides information to people who may deal with the property as to nature and extent of the rights which the person may have affecting the right, affecting their property. In other words, it enables people to find out.
Mr.
When-
Ali, this judgment has no relevance.
Relevant, your lordship, it is supposing by taking black papers converted to some valuable security or valuable.
You are not challenging that part. Are you
That is
challenging?
clear, your lordship.
No, so you have to now opt. I'm giving you the
That is
doctrine of
the-
election.
whether-
Which do you want to opt? The counterclaim or this?
So your lordship, the gift deed as well as the sale deed, your lordship, it has been produced from the custody of the defendant number one. It was not with me, that he has done everything, your lordship.
Custody, it was not from the custody of the defendant number one, it was custody, no, it was from the sub-registrar's office.
Based on
Sub-registrar's office, because that was proved as exhibit EA.
the- So custody is,
Mr. Ali, this is the third time the matter has come up before me. So I learned it by heart. First time Mr. Kukaska was there, he left. Then you came.
anyway,
Then
your
on
lordship,
that
property-
day I was supposed to dismiss,
property is
but
section-
I put this matter
property
today.
is section 68 and 67 is concerned of the evidence at your lordship. That cannot be given a goodbye, your lordship. Just because one says this is a gift deed and it is complete, gift is complete, and this is the sale deed, not proving that you.
Now, did you raise it as a memo in the memo of appeal in the first appellate court? Did you raise that issue as a ground of objection in your memo of appeal, Mr. Ali? No. No. See your memo of appeal. You have not raised that. Don't come up with all these things.
Lordship, in the memo paper, you have taken that down, your lordship.
No. In the first appeal, you did not take that ground.
First of all.
First appeal. Then only it becomes a substantial question of law. You were not there in Gwalpara. Gwalpara, Golagat, where? Where is this?
This Barpeta, your lordship.
You should have conducted the trial. Appeal.
But in our memo, your lordship, in the
Forget about the memo.
second appeal, your lordship.
Forget about the second appeal. Second appeal cannot, first of all, second appeal, they cannot even be a ground of objection. You are only to do it on a substantial question of law. In terms with 100(3).
So your lordship, I'll have to go through the whether actually there is no job has been taken on that.
So what do you want?
So
The appeal has been pending from
This matter of what happened,
5
your lordship,
to 2025, I gave you 1 month to that council. Then on 3/3/2025, I've given you 45 days.
the suffer going there, the quick time your lordship is in your lordship. I'll go through it, your lordship. And the person who engaged me, your lordship, is not here. And that is the problem, that it might be with him, your lordship, the papers of the party.
But next day, if I dismiss, then
What
it
I
is
did
with
is
cost.
dismiss your lordship, because I have already lost to court, your lordship.
You have not only lost, we got a decree out there. Now, only thing you go and do good service out there by asking that I now pass that order giving that liberty which is given at paragraph 15. That they can move under
No,
152
otherwise,
for correction.
it is dismissed also, your lordship, supporting, I will not believe that. In the sense, your lordship, that decree can never be executed, and it will.
Don't worry about that. No, Mr. Ali, don't worry. I think only one way by which you cannot be the loser is by withdrawing this. Because if I have to pass an order, I will grant the liberty in terms with paragraph 15 of that judgment. 2003, 1 SCC, page 197. And if that I observe out there, it will have far-reaching effect upon you. You can very well go under 47 and say that this cannot be done.
Hearing of the entire matter.
Not necessary.
Entire matter.
No. Mr. Ali, first of all, this court has to formulate a substantial question of law, which I am not ready to formulate any of it, which you have suggested. And if there's no substantial question of law, I can dismiss. Which I always do at the stage of order 41 rule 11.
All substantial question.
There's no substantial.
A degree has been passed, your lordship, which is not effective. And unless
Not?
it is not effective.
Not necessary.
And there is law,
Not,
your lordship.
if it is not effective, you should be happy. You should be happy.
No,
Why you are before this court?
When the High Court will not allow such a degree to.
Don't worry.
Procedural.
I will make it correct. Under order 41 rule 33, I'll make it correct. And taking into paragraph 50. Wait, what do you want?
Which that. What's the matter?
Let us fix a date now. When do you want? When do you want it? Let's finish it off on 6th of May. Mr. S. Ali, the learned counsel, appearing on behalf of the appellants, seeks for further 2 weeks' time to go through the records in order to ascertain as to whether there is any substantial question of law that can be formulated in the instance. This is the matter on 6th of
Some meeting. Time to obtain certain. Taken by next week, for election hearing. Next week, madam. Download the system, basis for a lot by the self party. Fully different from the. Not so. They have been, but they are also. They have been about 70 of 22 madam. Madam. The 10 and 11 is running the. It's the other by Washington.
Now, Mr. Saru, see page 36, paragraph 9.
This, right, but they have to, they have to have the part, certain mellow. This is not the agricultural land mellow. It should have only should have for ejectment for Mr. should have mellow. Which was occupied by their finisher in the place. That's the condition status mellow. Then after expiry of the
Now, it's observation being made by this court. In fact, it's false. Unless there is a challenge to this before the Supreme Court.
No, what actually, what are they are the third party members. They cannot claim to be the third party members. They are the party. They are the legal acts and substances of origin, the judgment of a matter.
No, their basic case was also the erratic appeal.
Right.
This is your case.
They are-
This has already been dealt with by this court
Right.
earlier. Paragraph number 9.
Right.
If that be so, in fact, it's false.
If they have also instituted treatment or that is. Statute number 49 of 12 malo. For declaring that the decree of paying statute number 23 of 75 is null and void and is not in executable malo. That suit has already been dismissed by the trial court malo. That is that they perform a fee, first appeal. That appeal is pending now.
Now, with this finding, your entire case false.
There was one there was something that he expected to said, the it will pay me.
How come do that? Any devolvement of the right during the pendency of the suit will be subject to the outcome of the suit. Rightly or wrongly, this is the finding. And having not been challenged before the Supreme Court, nothing remains. Because that's why I picked the matter today is to finish it off. Because this is an execution dispute.
Right, I said that.
So we pull it the matter today.
That's it. I give it to you.
This is the only ground here, which have already been taken care. Huh?
Section 66
Of
of the Assam Temporary Settlement Act. When Satyan is issued, Satyan is issued, the son of civil code.
But the Khatian was issued after the suit was declared, you see. Suit was decided.
You're wrong.
So at that point of time, there was no Khatian.
The time of filing. After
After any Khatian has been issued subsequently. Has been issued subsequently. Now let the decree be, decree is only in respect to the civil premises. Let them technically go ahead with the
ultimately, same thing, he will be ousted from the land.
outside of the land, how much Khatian you have been issued, that is a different aspect altogether. But the question is, as regards the suit premises, it has to be given. Would not have got a Khatian in respect to this, because the suit premises belong to you and you were an employee only.
Except that he got it.
Grandfather was only an employee.
He is not agriculture is now. He, the Khatian can be issued only for to the agriculture is now. Cultivating the land. Next thing, next thing.
No, next thing.
Next
thing.
So I have to go through.
What?
I have to go through.
You have enclosed the document, the judgment you have enclosed.
Yes, I have entered.
Then?
But look, if it passed without jurisdiction, whether they
No, without
taken into
jurisdiction.
consideration or not.
Second appeal has also been regarding the first question of law during the pendency of the original right and only wife was substituted. He submitted that on the ground that the official I am not satisfied with the submission made by the AI in as much as the sufficient representation. Further, it is a suit for ejection from the house and this house was given to the defendant while he was in service. He retired from the service on demand and thereafter he did not vacate the supremacy in spite of the remitted leave. Above order in second appeal was passed on demand and the time granted by the owner expired on been rejected by the. When were you granted the Katiyan?
In the year 95 kilo.
So then why didn't you bring it before the trial court? Or the first appellate court, or even
Actually,
before
I
the
was,
second
I
appellate?
was not party.
What?
I was not party to the.
No, you were sufficient representation, you filed the second appeal. So,
This is the why it is Saturday, setting along and 6 months time was given to the judgment that to make it their become to measure.
too much. There is some preliminary objections, the court did not find it, which court did not find it? The grounds of objection were 12 years. The judgment which was passed on, the second appellate judgment merged with the first appellate judgment. Obviously, the period will be counted from the second appellate judgment, and the second appellate judgment was on
Year 90.
no, 2000,
So 2000,
31/10/2000. Above order of the second appeal was passed on 31/1/10/2000.
That was
Time
time.
granted was expired on 2001.
that was
So that is within time. So that is your first ground of objection. That without calling for the reports of the second movement are based on one gender of legal error. That has also been taken care of by the second appellate states. It is not there. Then the second thing, if you have not brought on record when you should have, then obviously.
second appeal. I was
And the Khatiyan could not have been given over the suit premises.
in respect of the land.
But maybe, whatever may be, but the land, whatever may be, it is a different thing. But as regards the suit premises, we have no business out there.
Once the supremacy will be evicted, I will be evicted from the land.
So what? You stay nearby, bring another house nearby.
But that because
You have no business over that house. Now, the next question is, we have it on Tuesday next, but with the cost of 1 lakh. This is an imposition of, this is a serious litigation. This is abuse of the process. Matter having been heard at length, lift the matter to 29 April 2025 at the Court of Police. First item, we dismiss with cost of 1 lakh.
Hearing item 7 and 8.
Yes, what did you find?
I last occasion, your lordship had posed the point at query as to whether we are be able to abandon C, but that we thought over it. We go down to that proposition, we cannot maintain it without. So C is the question of the banking. But I guess that the other aspect as to whether when the action stage is the challenge, maybe by a revenue officer or revenue court or other court, whether the state becomes a necessary or is it only a proper party. What I found judgments, old judgments of High Court, the lordship had. First is by the division bench of the Rajasthan High Court, was offered by Justice K. Monsoor, was the Justice of the Rajasthan Court. And was that Para 11 onward, several authorities have been discussed. But I the only ground, the ground which is urged in support of the contention that the state is a necessary party is that the suit challenges an act of the state, and therefore the state must be made a party. In this connection, reliance was placed on so and so, in which it was held that if it was desired to question an act of state directly or indirectly, the contention must be raised on a suit duly constituted to which the government must be made a party. The facts of that case, however, show that the state was held to be a necessary party as by an act of the state. The property had come to rest in the state. The case related to lands forfeited by Lord Canning's proclamation after the mutiny of 1857. Some of the forfeited lands were granted to the defendant. Thereupon, a suit was brought by the daughters of the Nawab, whose estate was forfeited, claiming the property as theirs under the Mohammedan law. Their lordships observed that the forfeited estates were not an asset at the time of the Nawab's death and could only be treated as such when the government title was disputed. This could be done on a suit duly constituted to which the government must be made a party. It is obvious from this that government was a necessary party because it had become the owner of the estate. It was later re-granted to another person. In the case before us, all that happened was that the disputed property was ordered to be transferred from the plaintiff to the defendant, and the government at no time claimed any title in it. It is not necessary that the state should be made a party in every suit in which an order of this nature is happening. Well, we can perhaps skip forward. Another case that was relied on by the responsible, another case that was relied on by the respondent is so-and-so versus so-and-so. In that case, it was held that the suit to obtain a declaration that the plaintiffs possess certain rights in a shamila can be maintained only if all the proprietors have been included as parties. This case has obviously no application to the facts of the case before us, because the state is not being included on the ground that it has any direct interest in the property which has been transferred from the defendant to the plaintiff. The next case to which reference is made is so-and-so. That is related to Nozul land and was filed against the Municipal Council of Bellary, and the state was not made a party. It was held that as the land belonged to the state and had only been given to municipality for municipal purpose, a suit for declaration that the plaintiff was owner of the land required that the state should be made a party. Here again, the state was a necessary party because it was the owner of the land, and this case also does not apply to the facts before us. 15 is important here. The mere fact that some action of the state is being impugned in a suit is not enough to make the state a necessary party. Though in certain circumstances it may be proper.
Why did I pass that last order? I did not pass my last.
Lord, if I can query whether this can survive at all without that paper.
So you will like, whether you would like to abandon that. The reason why I passed that order was a thoughtful reason. It was not just for the sake of it. The moment you are not abandoning the relief, which makes the state the necessary part.
Now, Manoj, the other one, what I've gathered from these judgments is just a point of view. They have said, my lord, there can be challenges to orders passed by government officials, including revision. Now, if these judgments say that unless the interest of the state is in the property in itself, these orders can be challenged where builders say the rights are decided. These orders can be challenged even without state being a necessary party. Of course, at times it can be held, but it is always desirable to have the state on record. But unless the state itself has an interest in the property itself, the fact, the mere fact that some action.
No, if I hold equity and validity, can you file a separate suit? Answer there. Still not going to hit you. Without the stating by the party that both the equity and validity, can you file a separate suit?
That
Validity, equity and validity. Having been passed against an authority where the authority is not made.
That is why I wanted to rely on the other judgment also. It said that, and on others, so these have said that this order, when they are set aside, they're not in essence in order against the state per se.
Is an order.
And therefore,
Therefore, I ask you to give up that relief.
give up that relief. That's your worship.
Then without giving up that relief, you cannot succeed. You cannot have right title over that property.
So that is why I cannot apply.
Without C being taken away, you don't have right title.
I absolutely agree to that proposition.
So under such circumstances, if I hold that the decree is a nullity, because without C, the C being decided in absence of a party, who is required, then to be
That is what I'm trying to. Persuade you not to. So the other judgment says that because all the court has to see is whether this proceeding under section 23 was a nullity. or not.
you have a defense. The court, the trial court and the first appellate court holds that the BC has not done it properly, the E has not done it properly, and all this thing that without a defense. My goodness. Are you supposing to say that wherever there is a challenge out here, with provision, you don't make that person a party?
That's
So
why
the Rajasthan High Court, the Madras High Court, which this is High Court is Madras. The Rajasthan High Court, the Madras High Court, whoever has passed that order may have passed it. With great respect to the judges, I don't agree, and I would not agree to such a proposition.
Well, that proposition is formulated from the other authorities. Just for a moment, if the lordship has that Madras.
Let us do one thing. Let me allow the appeal. We go to the Supreme.
Just so that your lordship can get right to them. But also the Supreme Court judgment that just made that on record also. Here, one of the issue was whether, of course, it was slightly different context. Here, the issue was whether of authority which has passed the order, it's required to be included in a challenge to that particular order, maybe in an appeal. Now, they drew a distinction between quasi-judicial and regulatory functions, and held that whenever it's regulatory, adjudicatory, then that authority may not be before the court. This was, of course, in the context of an appeal, my lord. The lordship sees para 16 onward. Because even if I increase the deputy commissioner, he's done a judicial act, a judicial function, a judicial function. He can never come forward and defend his own judgment. Para 16 onward. The respondent referred to judgments of this court and of various high courts for the proposition that statutory authority exercising quasi-judicial function cannot defend their orders in appeal. Before we proceed to determine whether ERA is a quasi-judicial authority, it is necessary that we first clarify the contours of this proposition. The judicial principle that a judicial or quasi-judicial authority must not be impeded as a party to an appeal against its order is premised on two reasons, both rooted in constitutional philosophy. The first reason is that with the impediment of the judicial or quasi-judicial authority with the respondent,
they will be required to justify their decision before the appellate court. This is contrary to the established principle that judges only speak to their judgment. Any dilation in this of this principle would lead to a situation where every judicial authority would be called upon to justify their decision to the Court of Appeal. This would break down the entire edifice of the judicial system. Now, subsequently, in so and so, a civil suit for maintenance was filed before the Muslim Gorakhpur. The plaintiff filed the division in the court of the district judge Gorakhpur, which was dismissed. The order of the district judge was challenged in a writ petition before the honorable before the High Court, which was also dismissed. A special writ petition was instituted vacating the order of the High Court. In the writ petition before the High Court and the special writ petition, the district judge Gorakhpur, the court judicial and civil judge were pleaded as respondents and contesting respondents respectively. A three-judge bench of this court deprecated the practice of including judicial officers who had disposed of the matter in a selective case. We do not approve of the course adopted by the petitioner, which would cause unnecessary disturbances to the functions of the judicial officer concerned. They cannot in any way be equated to the officials of the government. It is high time that the practice of including judicial officers disposing of civil proceedings as party to writ petitions under Article 226 of the Constitution or special writ petition under 132 of the Constitution to stop strongly deprecate such a practice. Now, ultimately, at paragraph 33, they found a distinction between adjudicatory and regulatory work. Paragraph 33, the principles have been summarized. Of the above discussion, the following principles emerge. An authority, either a judicial or quasi-judicial authority, must not be impeded in an appeal against its order if the order was issued solely in exercise of adjudicatory function. An authority must be included as a respondent in the appeal against its order if it was issued in exercise of its regulatory role, since the authority would have a vital interest in ensuring protection of public interest. An authority may be included as a respondent in the appeal against its order where its presence is necessary for the effective adjudication of the appeal in view of its domain expertise. But I can understand the judgment is distinguishable on the sole point that it is concerning an appeal and not a civil suit. But Madras, one paragraph is also allows you to case. Taking the proper and necessary parties, again, what was already certainly explained in the earlier judgment, they were reiterated at paragraph 50. This is one aspect that I just like to point out. From the top manner, the logic takes up the 7 times. This court has sufficiently dealt with proper and necessary parties referable to order 110. A necessary party is defined as someone who is indispensable to the suit and without whom the suit cannot effectively proceed. A proper party, on the other hand, is a party who has an interest in the adjudication of the suit, though he may not be a person in whose favor or against whom a decree ought to be made. The court has further held that a party who would not be a necessary party Merely because he has an interest in the correct solution of the question involved. Would be a necessary party only when she would be bound by the result of the action and has a director legal interest in the process. So, my lord, Rajasthan High Court, if I just draw the analogy, Rajasthan High Court says that collector can decide a lot of things. But unless and until it has an interest in the property itself, the mere fact that this action of the state is collaterally under challenge will not make the state a necessary party. And Madras Court is again similar in a way. Madras Court, this one paragraph, if I read out, no relief is asked by against the government, and the court is only considering an order passed by an authority constituted under the endowment. The last page. The last page, first paragraph. Governor under the Madras Hindu Religious Endowment Act, the defendant had applied for a resumption of the land on the ground that it was restricted for a period exceeding 4 years. The collector, yes, the revenue authority permitted them and said that the land should be resumed as Sarkari, and therefore the plaintiff challenged the decision of the revenue court, saying it could not have been done. The revenue authority did not have to. Now, the last
are the parties in the suit? Before it is reported?
The one who was claimed to be the lessee was the dependent mother, and the other was the inamdar, service inam attachment. And
Now, why these judgments have no relevance? Is because of section 80. Because of section 80, 1976, it was amended. Now, see, section 80. Same as otherwise provided in subsection 2, no suit shall be instituted against the government, including the government of the state of Jammu and Kashmir, or against the public officer in respect of any act purported to be done by such public officer in his official capacity until the expiration of 2 months next after notice in writing has been delivered to and let out in the case of suit against influence. Now, this is why it has been now necessary, this happened only in 1976. The judgment has no relevance.
section 8. Section 8.
So you are challenging an act of a public office.
That is true. And that's a in such a circumstance, there will be a public authority become a necessary or proper party is the question.
Not necessary, it is absolutely necessary. Without the public authority being made a party, not a. Where it goes to the extent of saying that even a judgment passed, even in a case where a constitutional virus is also being challenged, the government is not required. Even in a recent judgment of Justice Department is also wherein it says that in a writ proceedings, the constitutional court can set aside a subordinate legislation, but they have to give due notice and clear the government to the report. This is the law.
Last, to submit this, why I say that just be a proper party because this is a state, and eventually, without review, the action cannot be effectively decided, and the other is very desirable. Now, here is the thing, order and priority, that would automatically disallow the moment we can establish that there was no landlord in tenant. Because if the only question to eventually decide the suit, in my understanding, was to see whether there was a landlord tenant relationship. To decide that particular issue, because it's a, we can't say a dispute whether it's very clear, government is not a necessary power. So now the moment it is decided that he is not a tenant, the acts he is to apply, the proceedings under 23 become bad, and the order, challenge of prayers, it becomes a nullity. So therefore, to effectively decide the new issue as to whether the appellate was my tenant or not, we do not require the presence of this. Because it's a rural relationship of landlord and tenant, which can be decided by the persons who are privy to that transaction. So if or deciding that effectively the state is not a party, if the state become a necessary party only because the order is under. Because that is last line what it says was, if I may just read it, no relief is asked against the government if the court is only considering an order passed by an authority constituted under the Endowment Act. In this case, the collector, whose order is attacked as being one without jurisdiction, which is raised by the second issue in the suit. It is again for the court to find whether the collector who ordered resumption proceedings had acted within the powers conferred on him under Section 44B of the Hindu Religious Endowment Act. It cannot be stated that the government is a necessary party in such cases where the only question that the court has to go into is whether the order is void by reason of the authority who exercised it having acted without. As pointed out, already no regime is answering the government and plaintiff in the dominant status cannot be compelled to act the government as a party. The government is not elected. It cannot be said, however, the property that the government is not a proper party, since it is impossible to contend that the government absolutely has no interest either in resumption of proceedings or as to decision on the question whether a particular enactment is altered. So it could be a proper party, and even if it's a proper party, then the proviso to section 99 not. Because then it becomes an irregularity.
1 and 2 pertaining to prima bench for hearing.
May I please, Your Lordship? Your
Yes,
Lordship,
Can you hear me?
yes, Your Lordship. Your Lordship, on behalf of Livika, she is undergoing treatment right now due to some emergency. She'll be undergoing surgery the after. So if this matter can come up on 13th May or any other date, according to your,
13th May.
yes, 1-3, 13th May.
Okay. I will also taking into account here. Yes, where is Mr. Empty Longshirt?
Yes, Lordship.
Where is he? Where is he?
Lordship, my senior is indisposed, so he couldn't able to turn up today.
Hmm?
Indisposed continue.
Lordship, my senior is indisposed.
Indisposed.
Yes, Lordship.
Yes, yes, Mr. Anand here. Please. Help us go. What has happened in this case is that person was taken into custody. After being in the custody on 29th, 29/10/2016. Medical report, everything fine, everything was fine. The next morning, he was found and there was nobody in the lockup. There were 2 cells in Puliman police station. There was nobody in the lockup. So he was found strangled or and the report says that it's a suicide. For which first there was a case of there are 2 petitions filed. The first is the petition pertaining to asking for a CBN. And the second is for the constitutional court compensation in that. Now, while I was taking up this matter before the Kohima bench, it's a very old matter. While I was taking up this matter, I formed a commission of inquiry to ask the district judge, Session Judge Kohima, to make an inquiry. The commission. He submitted an inquiry saying that there is no suspicion. But the fact remains that this particular person was in police custody. When he was in police custody, there was a ventilator out there, which was, his height was 5'3" and the ventilator was 6 feet, at the height of 6 feet. First of all, where did he get the rope to strangle himself? Secondly, how did he die? Everybody says no. We don't know what has happened and all. That can't be an answer. Because first of all, when he is there in police custody, the police is responsible for that. It is the case of constitutional tort. So I would request you to assist this court as an amicus, right, so that you can help out this thing. And I will also give you a copy of the inquiry report where you will find out the evidence being taken of all the persons concerned. And their basic concern, thing which is mentioned out there, that they did not see anything happen and then found him be strangled out there. And while strangling also, another very important thing is that his feet was touching the portion of the feet was touching the floor. If the feet was touching the floor, that must have happened immediately if he had strangled himself by himself. Then obviously there couldn't have been a case of that experience, but they say there's a particular word used there. Second report is interestingly, there was a CCTV installed in the lockup cell also. And this accident happened in the toilet, not in the lockup cell. Happened. So you have a look at it. This report, you have it on 13th of May. I'll ask the registry to provide you the papers of both the restitution, when there's the inquiry. It's AIME, the Learning Council, Government Advocate, appearing on behalf of the state of Nagaland, admits that Miss Livika Sumi or Visumi,
Visumi.
council who represents the state of Nagaland in the instant matter within this post and seeks for an accommodation on 13th of May 2025. This court having perused the entire report as well as the material and entire report so submitted by the principal district and section that's Kohima, as well as the materials and report, is of the opinion that for the purpose of a proper adjudication of the proceedings, assistance of an amicus would be essential. Considering the above, this court had requested Mr. Anand Kumar Bhunia, the learned counsel, as to whether he would like to assist this court. Mr. Anand Kumar Bhunia submitted, the learned counsel submitted that he would have no objection in assisting this court in the matter. Considering the above, this court appoints Mr. Anand Kumar Bhunia, the learned counsel, as an amicus curiae to the instant instant proceedings, and registry is directed to provide photocopies of its reports along with the entire report dated 11/11/2024 to Mr. Bhunia, the learned counsel, so that he may be in a position to assist the court. The registry shall do the needful within 7 days. The name of Mr. Bhunia shall also be reflected as an amicus curiae in the court list. Okay. On 13th, madam,
Yes, your lordship, on 13.
I have appointed an amicus in this matter.
Yes, your lordship.
What is your submission? Who are you? Who is 3, 4, and 5? Huh? You are a plaintiff. And who are you? What? Satish Kumar. So there, your land is also X. Okay, what is your submission? What behind that? Don't jump into the judgment from where to pay. I will come to paragraph 6. This is why our judgment relevant. Therefore, I ask, are you going to waive? Are you going to waive prayer C? There's no para 6A. 6. There's no 6A. No, first of all, there is no prayer. The suit was for claiming for damages against Burari. What is name? Buri. Name was Buri Devi. As well as claiming damages and for possession. Nothing more than that. But therefore, my last order was specific. This judgment was shown by him earlier. Yes, that is why my last judgment was very specific. Are you going to waive off prayer C? You don't waive off. The order 1 Rule 13 only says about party. It does not say necessary party. Do you know why? Because of order 1 Rule 9. Order 119, read that order 119. Then the provided. That is the reason why. That is why when it is a question of necessary party, if the suit is being decreed, it will be a non-est decree. It will be a nullity. I remember there is a beautiful judgment that I think 1977 or something, 72. 72. When a decree is said to be a nullity, tomorrow you get a decree against the dead person. When you get a decree against the dead person, you get a decree against the dead person, it is a nullity. Why? So that person is not there. You are getting a decree against the dead person who is not there. That is why there is a question of bringing in what you call the legal representatives so that his estate is to be protected. Therefore, my question last time, the order was specific. That are you going to waive C? You can't waive C. You don't waive C. You can't bring in Monday judgment. The Monday judgment was specific that there was no release for fraud. And, and what for is for possession against gravity. They did not go for cancellation. So you were the original plaintiff. No, who was victim? So you are the original plaintiff. Tell me, where have you mentioned in your claim that the exercise done by the DC was without jurisdiction? Show me one sentence in the claim. The BN Sharma, you are for whom? You're a party. Very There is not a single statement to that effect. Then if you have filed an appeal against that, you must have raised these points. What happened? Where is the Board of Revenue order? It is. Mr. Bhawan.
I have not, because it's on 14/1/2004.
We have not exhibited.
That was
You have only, Mr. Sharma, you have only filed that writ petition. Eight five zero nine. Others did not. No, no. Who prepared the Board of Revenue? You only challenged it. Others did not. You only. But you were a performer dependent then. No, fraud is okay, but who has committed the fraud? Alone. So that authority is not required to be made a party. But do they have no right to say? When you allege an allegation against the state has no right to say. The state has nothing to say. Absolutely, there's no quarrel with that. But if the state cannot defend itself, no, you must have raised all these things before the Board of Revenue. You must have raised all these things before the Board of Revenue. No. Then why did you file the writ petition? Writ petition has been filed after the civil suit was going on. Then why did you file it? What happened in the Board of Revenue? Where's the judgment in the Board of Revenue? Where is it? Where's the Board of Revenue judgment? Because you have raised it and they have not assailed it. It was filed when? In 2004. When was the patta given to you? 2003.
9/5/2003. 9/5/2003.
2003. Suit was filed in 2004. Huh? Suit was filed in 2008, after 5 years.
So it was renumbered in 2000.
So the suit was filed in 2004, immediately after that. The suit was filed. Now the suit having been filed, what happened to the Board of Revenue's order?
Board of Revenue order, that was dismissed on 14th of January 2000.
Why there are two appeals?
And they filed against two set of defendants. Two suits.
Huh? But these are different judgments. And in both the cases, there is no stake.
In judgment, similar contents.
And both the cases 9/5/2003. In TR case number 1/2002-3, both. There is 80 of 2015.
Yes, 79 and as well as 80.
Let us see the some temporarily settled area tenancy. Because one of your grounds of objection, substantial question of law is 66. Isn't it? Have to take a look. Now, why being section 66? The bar
Are because of the fact that they have asked for this preparation of record of rights.
No, they have asked for ownership.
Already the ATC has given the young favor of the defendant.
Understood, but this is an order of ownership. Now 66 bar it.
Declaration of record of right, that's chapter 10, declaration, planning and organization.
And under chapter 10. Chapter 10 is called under the tribal area.
Right.
That is nothing to do.
Evidence of record. Change to- change to description of position.
So 66. So the ownership question cannot be decided in by the revenue authority. So it has to be only by a suit. So section 66, substantial question of law has no relevance. Think so many substantial question of law unnecessary. Well, here only one substantial question of law, 2080 of 2014. Other substantial question of law is not there, isn't it? As to whether without the stating by state of Assam or the authority granting ownership to the defendant by the order dated we also made a party, whether the suit was maintained. Right? That is the only one. And in the other case, whether an occupancy tenant under presently will be entered in the property of plant can be evicted from the land under his occupation before the provisions prescribed to one form. But here we are concerned with the question of the moment the cancellation happens to that order, which has been put of ownership. Now they have challenged only the ownership. What about the Khatiyan thing? You being entered, your name having entered in the Khatiyan, has it been dropped on challenge anywhere?
That is the player C. That is the player C.
See,
Player C.
the plane.
Right.
Also the entry of the name of the defendant is named in the capital of the plane by competent and law and by. So this portion, entry of demand in the revenue is comes within the preparation of reports. So there you see the challenge being there. So therefore, if C is allowed, your substantial question of law number one has no relevance. One has no relevance, you don't become an occupancy tenant. Number two also is out. Three, whether he an occupancy enjoys the permanent, C also, three is also gone. How is 4 relevant? So 1 to 4 is useless. So only you are on the question of the state of affairs. What do you have to say? You have heard the argument.
Santosh Sagari versus Purushottam Tiwari states that the entirety point based on the first time it was the High Court, the question of what in the case unless it goes to the root of the case and the question of non-gender of necessary party, the question which goes to the root of the pattern.
Does it say in Control Kadari?
No, that is in employee state insurance. Corporation 2022, the 60 online. And, there are 30 states. I think
Who goes to the resettlement? You have Control Kadari, it can be very well urged. And more particularly, order 113. Let to be this. It's only in respect of and the CPT, category differentiates between necessary party and party. I don't think they use the word proper party. It's different in the CPT. There's no concept of proper party in the huh? It only says about necessary party and party. If it is the proper party, then it should bring it immediately. It is similar to the jurisdiction. Or even an objection taken to the proviso to there also it says that if it is a question of these objections which can be cured, you should bring it so that if you don't bring a necessary party, it becomes futile. Therefore, the word the proviso makes it very clear. The proviso to order 119 makes it very clear. Without the necessary party, you can get out of this. I think it is only judicially evolved about proper parties. There is the simple judgment, I think, is the key to think about it. Yes, Mr. Dekar. What is the judgment of 1958 on necessary party and proper party? It starts with an R. Simple judgment, wherein it tells about the commercial interest. It is also brought on here by the 1992 CSCC judgment, CSCC judgment. Our start, Razia Begum, yes. 1958, na? So there, the concept of proper party is being developed. Anyway, then what is the next one?
Regarding the other points,
No, how, then they say that the state is not required to do it. The basic idea is that is an adjudicatory order. And as such, the contention can be very well, C has two elements. Firstly, first, the order. Secondly, the entries by which Khatian has been. One is the Khatian, one is the Ulus. Issuance of a Khatian is not an adjudicatory order. As per the this. So that is, but anyway, what do you have to submit on this?
only by this order of right is being it's not an adjudicatory right. Sort of right. This made by the side is not adjudicatory.
Now, this particular act, this temporarily settled area tenancy act, where it is expedient to regulate to the rights and liabilities of the agricultural tenants and the landlord in temporarily settled lands in the state of Assam. So, whether section 23 of right of ownership does not include the regulatory functions of the officer concerned. And then in terms of the judgment which has been cited by Mr. Descartes, it is not helpful in saying that when it is done in exercise of a regulatory order, then the authority is required to be made a party. And if you do judgment an authority must be included as respondent in the appeal against the order which it means to the exercise of its regulatory role since the authority is a vital interest in the ensuring the protection of the
That means also the ABC could have been.
Huh?
In that case also ABC could have been made a party.
Because it is in exercise of its regulatory powers. Because the act only regulates. And what else?
See, the one of the defendant making. He has already prepared. Against that order.
Isn't it an honest thing to do? He couldn't have filed a revenue appeal. The different thing, he filed a revenue appeal, but the question should have been by filing a suit. So obviously that would not have any impact.
But in this petition also, he has made mistake with the party.
He has made a state a party, but the question is, you have not brought on record the Code of Revenues order.
That was 11/14/2004 after the evidence.
How do I take judicial notice of that?
It was after the evidence of the given.
No. When Mr. Bolin Sharma gave his evidence, he exhibited the order of the High Court as Exhibit 4, by which notice was issued making directing maintenance of status quo. So the Board of Revenue order also has been brought in. But anyway, that has no relevance, taking into account. Now, is it necessary that the, in respect to an order by which pasta is being granted, the authority for the state is required to put it as the works respective opinion. Opinion is for the court. The opinion is the sufficient. So in my understanding, it has to that because that is the crux. Otherwise, your appeal is going to fall. In my understanding, it should have been made a party first. Right. Think about them, coming inside, thinking. I think reply to the state. We were given a Khatiyan. We were given a Khatiyan. Yes. Section 23 does not provide any identificatory mechanism. Section 23. But Rule 11 says about when you But you may have a good case. Without the state of party, it becomes very difficult. No, I'm saying on anything you have a good case. You may not find any objection from the state of it. You may not find any objection. But once taken done, you have to show somehow the state has been a party in the case. Without the state being a party, it is as if you are passing an order against the dictator. Because the knowledge yes, I do. I go to say the branch of even if the dictator is the only way out to take your right. Let's also think about of that. Because this is a like recently there is a judgment of Hausa also there is one And it is also the duty of the court also to look into the time who are the necessary parties. And it is a fundamental thing that happened in this. Is that there is a complete fusion into the what is the people are going into proper party and necessary party has been looking to do. But the fact that the older procedure only says about party and necessary party, there is no way out. It does not give you any way out. Therefore, you see, although one is working, is only in respect of party. Otherwise, it would have been necessary party. See, that non-gender of necessary party, the suit cannot be dismissed and not be dismissed. Why? Because of the fact that we have to give an opportunity to. If doesn't do that, then obvious. To the proper party. But when it is a you are otherwise, what is the point in having order 22? You can very well proceed against that person. What is required? Filing written statement, what is required? So these are necessary party. Therefore, it will affect. You cannot proceed against a dead person. Similar circumstances there, then I think that is the brutal judgment and language that will be. He is dealing with section 47. And they say, then when a decree can be said to be a null, then the legal representatives have not been appropriate. The party who is there, just for example, tomorrow you can very well ask for a, you can, okay, don't make them also a party. Can you do that? No. Just for example, you make a suit today against the state and don't make it. You cannot. Because he is the person who is going to be affected. We have a right to say. Someone will like. So I think this seems to be the best way out to give you that opportunity. See, this thing has gone back for another 21 years, but with a mistake being committed, the team has been pending for the last 11 years. We need for last. Do not get any objection from the state, but state. Well, the other programs which we have analyzed. In fact, consistency does not come in this. And more particularly, yes, for the purpose of it is only on the plan, they cannot be. But when the shooting has an overall effect, then the Board of Revenue or anybody can't give that thing. This is not something. Of course, this seems to be the only way. The point which I there is because if I were today also hold that this is a legitimate process. We are referring to that judgment of the Custodial, where he is dealing with tribunals and courts. Can't put them into the same authority, same statement. If that be so, we hold it in that regard, then we don't need to meet the state of party in any of the institutions responsible bank law. And make it issued under section 18. We need to maintain a party. Because this is a judgment, can it be a judgment in rem personnel? This will be a judgment in personnel. And a judgment in personnel only in regard to this. And more particularly, when publication is made, the official gazette. The acquisition of right, publication is known. Thereby meaning that this is a publication in respect to everybody. And you don't need to state the party. Publication is also another important. There was a stake. You paid the compensation or not? You have paid the compensation. Not paid. So this is a question of fact. Very well. You may have a good case. This is why I'm only thinking what is to be done. Initially, I told you can withdraw the liberty. Then again, the question problem will come with verification. Then I thought that how do I give you benefit on the position? Booking again, there will be a problem. The question will be done. Then the next thing is that regards the declared nullity. The declared nullity in that regard be able to find then in the verification. No, if I give you the liberty to file an application for increasing the stake, then obviously this can be for the proceeding. Because on merit you may have a good case. This is the thing. And I am very in possession. You are happy. But that but if I don't give you the liberty, then there is a problem. So that I know. But can the order be passed against any degree be passed in respect to prayer C without the state being a part? That is the only worry. Therefore, I'm saying. Can I dismiss? But Mr. Sharma, can I dismiss and now dismiss the appeal on merits? No. Can I dismiss the appeal on merits? No. I have to dismiss only for default. No, I can't. There are many Supreme Court judgments I can't. I can't do that. See, the problem is arises with the fact or the better. And have it will next Tuesday also. Think about it. Can you file an application for amendment to the plain service? And I allow the amendment, and then you. If that is a way. Think about it. Then you don't have that problem. You never know what the trial court will do as regards making him a party, and then invitation will have a. Will have a. So this party has to wait for that, but if I just run it like this, you may have a problem. If you file an application, can you file an application out there without being an appellate? File an application to the state of party. I can very well make him a state of party. Once I make the state of party, I will not be that. So the state has a right to stay. One way. And it will be taken from the date on which. Understood. But can very well apply the doctrine of relation back. See, that's what I'm saying. I amend it. Or if the court amends it there, then the doctrine of relation back will normally apply. Unless the court says that the doctrine of relation. Just find out. Otherwise, I'm reading with the judgment to the effect. To the because otherwise, the judgment is a nullity without the necessary party. And the judgment, the other judgments which we are referring, because, okay, we may say at best it can hold your judgment also to the effect of that it has an executive process and as such it is not necessary. But what do you say about making him the Khutian? Giving him the Khutian is also put to challenge. Now, if he has a Khutian, he has a right. He has, he gets his right. That Khutian is not an executive process. No, no. Here only your notice is there, asking for objection on the thing. Only for ownership business notice. Not for the purpose of. Think about it. If I pass an order to get applied, that the state is a necessary party and as such the state will agree. The duty was of the time to in view of the judgment of Justice Gupta and Justice Mitchell in June 2024, there is a judgment. In that rules that matter, which is the duty of the year which have not been looked into. And as such, I make the state party, the state director here to make them a party and then proceed with it. You can't find an application there. By making a party of it, then you will need to amendment of the claim to buy whatever one you take. So it will lead to an amendment. You can't find an application During people use the map will give
In three,
File. One year.
you paid it 5 lakhs within 1 year. Vacate within 6 vacate within 6 months. This is the possession within. I keep the matter pending. Don't worry. The pay is what? Then, then over. Vacate. Vacating and 1 year for payment. 1 year for payment. Vacating. For vacating. And pay with 30,000 per month. For these 6 months, they will pay 30. Pay that 5 lakhs within 1 year. File of fresh on the taking. Reference to the order passed by this court on 25/3/2025. The managing director of the Assam State Transport Corporation with the petitioner in the instant proceedings has filed an additional affidavit on 8th of April 2025. In paragraph number 3 of the same affidavit, it has been mentioned that what is this without affidavit? What is this business? It has been mentioned that without affidavit, the managing director of the Procedural Corporation had undertaken to vacate the land in question within a period of 1 year and further undertook that the amount of compensation amounting to 5 lakhs as awarded by the learned trial court to be paid within a period of 1 year. The said undertaking so given is not satisfactory. mostly when a state, when a Assam State Corporation Limited, which is a state within the meaning of Article 12 of the Constitution, has illegally grabbed the land of the petitioner and deprived the petitioner of its own use. Considering we asked the managing director to be present, this is without thinking. What does he think? He's taking this court for a joke? Mr. Tyrone?
If you want.
Huh?
You can file appeal.
This is not done. And who is going to?
File a case.
It is not satisfactory. Mostly. The state within the meaning of Article 12 of the Constitution, and they cannot be permitted to retain the possession of the land of the petitioner illegally. The said act on the part of the respondent or on behalf of the respondent operation, petitioner operation, is in violation to the mandate of Article 300A of the Constitution. It is also relevant to mention that on one hand, the petitioners have given an undertaking that they would vacate the land in question within the period of 1 year, but have not indicated as to what is the compensation to be paid during this period. There is also nothing mentioned as to why it would take 1 year for the petitioner corporation to make the payment of the 5 lakhs. Considering the above, this court fixes this matter again on 29th of April 2025. On the same date, an affidavit has been filed on behalf of the managing director of the corporation, bringing on record the list of their assets and liabilities, bringing on record their list of their assets as well as also their bank accounts, on the basis of which the title is the bank. Give a proper undertaking, otherwise the court is going to freeze all the bank accounts. Telling you. Mr. GM Sayola, the learned bank to file a to get liberty. To get liberty. Attempt again, accept. Yes, what is this? Matter, come up with it. Whatever. So you do. It has been. Huh? Now, what is your? Relate the court judgment based on mixing. Yes, 17 and 9, 17 and 59 is registration.
The plaintiff is claiming right of interest, stand for the document. This particular executive deed, subsequently, his name was not included in the agreement. What he has subsequently executed is to relinquishment, registered relinquishment deed by the legal heirs of the original owner. He had initially executed one deed in favor of the plaintiff. This is subsequent. Without giving any registered deed, the right of interest to be transferred. It's deed. The concurrent, no, it's a judgment of reverse. Order 41 to 31 is there. Appellate court dismisses the suit. Trial court dismisses the suit. First, the appeal court dismisses. Trial court judgment starts from page number 350 lawsuit. Issue number 5 is the relevant. Page number 26.
Possession also. Plaintiff has possession also.
He said I'm in possession, and the defendants also said that they are also. On the issue number 5 lawsuit, where the plaintiff has been right to interest. And possession.
Exhibit 5, 10, or exhibit 5, or 10.
Yes, referring to lawsuit. Page number 57.
The particular portion.
Start from page number 72. The warrant for determination is at page number 73. Paragraph 10. Warrant for came to a finding with regard to the possession. Whether the plaintiff is in the possession of the suitman, if so, whether the possession of the suitman conferring type. There was no such issue faced by the trial court. Other points are taken up for discussion to decide the taking.
Where is the decision as regards issue number 12, as regards right title?
Where is the
What is this? But isn't your suit dismissed?
yes?
So it dismisses on also on the issue number 5 as regards your right title and interest. That's okay, I'm not on board. But the fact that you have asked for right title interest as well as for possession. For possession. Now, how by virtue of exhibit 2, what is this exhibit 2?
Exhibit to the following unregistered deed.
Unregistered deed that he has right title, the expression title confers different form of right to the property, includes the right to possess and such property is so and so. Hence, in the backdrop, I have constrained the plaintiff has got a decree declaring possessory title. As such, the judgment and passed by AI is set aside. How is it possible? Possessory title. AI, what do you say? Yes. Then how can you get a possessory title?
Denied. The written statement has been denied, saying we are in possession.
But one thing. How is it possible? Hence, in the background, I'm constrained as such the judgment in decree set aside. Now, in the backdrop, I'm constrained to have a plaintiff is entitled to get a decree declaring possessory title. So only possessory title, no declaration, no consequential relief. So where is the question? When your main relief is on the basis of your right title and interest, are you, what is your claim? Let us see.
Plain lordship declaration of identity.
Declaration of plaintiff right title and possession over the suit land. Yeah. Confirmation of possession over the plaintiff over the suit land.
Yes.
Permanent injunction not given. How can there be only a declaration? Isn't it in violation to the proviso to section 34? Let me interfere. We don't require the Supreme Court judgment for that section 49 categorically mentioned that for political purpose one can very look into that there is a sale deed to be. The sale deed and handing over of possession out there can very well be looked into it for collateral as regards possession. There is no quarrel. But how can a possessory title be declared without there being a permanent injunction? What is the value of the possessory? That means only declare the possession in your favor. It is not. No. But there is no sale deed.
With regard to the relinquishment.
Impeachment had,
Exactly.
there cannot be a relinquishment in favor of anyone.
Exactly.
Relinquishment is
Started.
what is this formality? Formality is what? Sale deed.
Absolutely. Then it's one form of agreement.
An agreement. Formality is
Yes.
an agreement.
One form of agreement. Even with regard to the signature, there is no mention by the
Formality
legal
is something more like an affidavit.
affidavit.
More like an affidavit. Okay, I have.
And there is no proof with regard to the signature, which has been proved by the executed by the original. When the legal heirs came and deposed before the learned trial court, but there is no mention whatsoever with regard to the execution of that. Only thing is that we have this executed the relinquishment deed, and there is no proof.
Who are you? Who are you?
I am the legal heirs of the original owners, whose name is reflected in the relinquishment. Although I have not executed any.
You did not file a suit for recovery of possession.
We have made a mention that we are in.
Then why have you filed the appeal? You should be happy. You should be happy. What right does he have? It's only a declaration.
Is that by way of this appeal, the ownership right has been declared.
Not ownership. Possessory title.
Possessory title, the title
Then-
is declared.
Possessory title. Only the possession has been
Because
declared.
this
But that decree cannot be put to execution.
is that the decree cannot be put to execution, but how this decree has been passed, because the particular finding of the on a trial court.
But if you have not filed a suit thereafter, why haven't you filed a suit?
Their lawsuit is not being filed.
If you have not filed a suit for recovery, whether adverse possession would not hit in.
We have also made a mention in our written statement. Very important. Possession of
But there is now the declaration is given.
given with regard to possessory right, but there is no evidence as such with regard to possessory right.
I'm not on that, Mr. Chaudhary.
So that I understood, lawsuit. I have to go for file a suit for this, for recovery of possession. That means I am admitting that fact. So long as I am not challenging that aspect of the matter in appeal, so I am admitting the fact that I am not in possession, they are in possession. So right? Indirectly I am admitting, but we are not admitting.
But your substantial question of law has no relevance out there. How will it have relevance? 17 and 49 is only in respect to the right title interest. But for possession, is it required?
Exactly. If it is not required, then the misinterpretation of the evidence, because there is no evidence as such with regard to this.
Why should I look into it in a second appeal? Misinterpretation. You have not given any evidence. They have given evidence. They say that they are in possession.
Directly affecting the core issue lawsuit. When that particular evidence, the interpretation of evidence is directly affecting the core issue, that is the substantial question of law, because it has been based on that particular evidence. Interpretation of that evidence, the learned law appellate court came to a finding that a possessory right of the plaintiff.
You did not give any evidence to the effect. You did not give any evidence.
There is no evidence to part of the defendant. The plaintiff is to prove his case based on his own strength.
But he has given his evidence.
And there is no evidence as such establishing the position. Only
He
the
said that
plaintiff
he is
number
in
one has made a
possession.
mention that I am in possession.
Could you break his possession? He claimed that he is in possession. Could you break his case that he is in possession in his cross-examination?
So that question was raised.
No, not raised. Could you break it?
The suggestion was
Suggestion, no. Could you break it that he is not in possession?
there was evidence on our part.
That is not a substantial question of law.
But the 4131 is always their loss because there was no
4131 is for what?
independent discussion so far as the issues are concerned. There is no such discussion. Because the only point for determination not because the plaintiff is not claiming any rightful interest based on adverse possession. Because plaintiff absolute claim to the issue was
No, here the decree is only that declaring her possession. That's all.
exactly
It's only a confirmation for it. That's all.
possession, but there was no such prayer made in the plea.
It is there.
Declared
Well,
rightfully.
no, 12 feet. Page 21.
For confirmation of possession prior, these are consequential really prior to that the declaration of rightful interest.
So there is a declaration, that's what I'm saying. The declaration is there without possession as well as for confirmation of possession. Is there?
It is that on a trial court, is the scope of the ground that the plaintiff could not prove by way of any cogent evidence with regard to their rightfully interest, according to rightful interest about the suit length. Now they have preferred the appeal. The plaintiff preferred the appeal that was resolved by the learned law appellate court. The found that there was evidence on record that the possession can be declared. So what is that evidence? There is no discussion as such in the entire trial court record, the law appellate court record, with regard to the finding of the possessory right over the court. There is no such finding. There is no such evidence. But there is no
Potential question of law to claim has no relevance.
when there is two contradiction, Lordship, when the plaintiff is saying that we are in possession, when it is
But you have not proved.
that I have not proved.
Then
That I have
plaintiff has proved. Plaintiff has proved that.
plaintiff has proved in the form of some statement. I can understand the statement because there is no rebuttal evidence that is there. The fact is that Lordship, when the rightful interest is not being proved, whether on the basis of the possession that has been claimed by the plaintiff, whether the right can be heard.
First of all, you have to prove that you are the owner.
So that aspect of the matter we have made a mention.
You should have, see, the moment a possession declared, it is only a possession is nothing more than that. There is no declaration of right title over the land. Only a declaration of possession. That means possession. He or she That's all, nothing more than that. So therefore, it is more like it is more like this thing which is being passed is more like a 3 4 year. It is being passed on the 146, 145.
Here in this case, what is the expression title? The lordship kindly understand.
No title, don't I will make it, it is only.
It can be clarified.
It is only, it is not a title. Yes, there cannot be a title, potentially title. But it has to be only a declaration or it's only a declaration that Indian profession. That's it. I'll make it clear. They cannot be a possessory title. The concept of possessory title is in foreign. Where is the possessory title concept? It's there. Have you ever heard of? Although I see it in the plains, the different. Yes, madam. Only decree, it is only decree confirming that you are in possession. Which one? No, that is. When was exhibit 2 done? Huh? When was exhibit
P1
1960? Huh?
P1 1960.
What is the date?
P1 law. Part of January 1967.
67. No, no, no. We have to interfere. Madam, you have to interfere page 78, the last line. It has a punishment of. Because how can he take into consideration foreclose all sides to hold the plaintiff is in possession of the flat since the date of purchase on the strength of exhibit? There cannot be a date of purchase. No, not maybe in possession, but not from the date of purchase. Court could have said that he is in possession. That's all.
I'm just referring to cross examination.
Okay. The question is what the word they could not have used the word the date of purchase. It could not have been a purchase. That is it under section 49. What is not it thing that you are in possession? Court could have declared that you are in possession, but from which state it could have declared, but not from the date of purchase, basing upon exhibit 2. But exhibit 2 cannot be considered for anything for a date of purchase. Will you beat under that? You have it very well. Because they are like good right.
This is dangerous. We have the right to possess because lawful possession of movable property confers good title on the possessor and retains the whole world except the legal owner. Understood, but we not claiming ownership. This is a first appellate project.
This is the interest of the respondents herein and instituted a proof being statistical number 453 of the 2006. In the same case, in the case of the plaintiff, is that the treatment described in the schedule to the plaintiff was one Dr. Bhupesh Chandra Dev Chaudhary. Bhupesh Chandra Dev Chaudhary was a doctor by profession who used the shop house standing over the food plant as pharmacy for giving treatment and for examining the patient. Using the same day, Dr. Dev Chaudhary, he wound up his medical practice and sold the food plant and the shop house standing thereon to the plaintiff by executing a secret sale of 1967 and handed over the possession. Thereupon, the plaintiff continued to possess the state land as the owner of the state possessed the state land. Subsequent thereto, after the death of Dr. Bhupesh Chandra Dev Chaudhary, his son, one Subrandu Dev Chaudhary, who is the performer defendant number 4, executed a registered deed number 5240 dated 27/10/2003, thereby relinquishing his right over the street land in favor of the plaintiff. It is the further case of the plaintiff that the performer defendant number 527 also orally relinquished their right in favor of the plaintiff. The further case of the plaintiff is that the defendant, the principal defendants who have no right, title, and interest or possession over the food land, with a malafide intention and illegal motive, tried to grab the food land from the plaintiff, which resulted in initiation of proceedings under section 145 and 146 of the Code of Criminal Procedure 1973. The action on the part of the defendants to grab the state suit land have necessitated the plaintiff to institute the suit, seeking declaration of the plaintiff's right, title, and possession over the suit land. Semicolon. For declaration that if any document collusively created by the principal defendants in respect of the suit land, the same shall be treated as void, inoperative, and illegal. Semicolon. For confirmation of possession of the plaintiff over the land described in the schedule to the plaintiff. For permanent injunction restraining the principal defendants from interfering in the peaceful use, occupation, and enjoyment of the plaintiff over the land described in the schedule to the plaintiff, etc. The defendant, numbers 1, 2, and 3, filed their statement wherein various preliminary objections were taken. It was mentioned in the written statement that neither Dr. Bhupesh Chandra Dev Chaudhary nor his legal aid had any were owners of the suit land. It was also mentioned that the plaintiff had no right, title, and interest over the suit land, and even there is no interest of the plaintiff over the suit land. It was also mentioned that recording the name of Dr. Bhupesh Chandra Dev Chaudhary in the revenue report could not confirm, could not prove the ownership until and unless the source of title had been proved. It was also mentioned in clause number 18 of the statement that the suit land is the exclusive ownership and possession of the defendant. And as such, the question of grabbing the suit land, grabbing the land and grabbing the suit land does not arise. The basis of the pleading. Further to that, the defendant have also refuted the entire case of the plaintiff. On the basis of the pleading, as many as 6 issues were framed by the learned trial court. The same issues are reproduced herein under page 6. On behalf of the plaintiff side, 4 witnesses were examined and 12 documents were exhibited. On the other hand, the defendant did not adduce any evidence, neither not adduce any documentary or oral evidence, but only cross-examined the plaintiff witnesses. The learned trial court, by the judgment and decree dated 17th of December 2014, dismissed the suit. Dismissed the suit on the ground that the plaintiff side have not been able to prove the issue for determination. It is relevant to take into account that when deciding on the issue number 5, which is of vital importance, that is as to whether the plaintiff had right, title, and interest in possession over the suit land, the learned trial court decided that the plaintiff did not have right, title, and interest over the suit land. However, it is relevant to mention that the learned trial court, when deciding the issue number 5, did not decide as regards the possession of the parties. The plaintiff being prepared an appeal before the court of the civil judge, learned court of the civil judge, Karimgaj, was registered and numbered as title 18 number 7 of 2014, which the learned first appellate court by the judgment in decree dated 7th of April 2015 decreed the suit in favor of the plaintiff only to the extent of declaring the possessory title of the plaintiff over the suit land. The other relief was sought for in the suit was granted. In the backdrop of the above, that this court now consider as to whether the substantial question of law was formulated by this court is involved in the instant need. The substantial question of law was formulated is on the question as to whether the learned lower appellate court has misappreciated the evidence on record as well as section 17 and 49 of the Registration Act, resulting in erroneous finding. From a perusal of the claim, it is seen that the plaintiff claims the right title and interest over the suit land. On the basis of an unregistered deed of sale dated 1967. And I have also sought for confirmation of possession on the basis of being in possession of the suit land. From exhibit 2, which is the unregistered deed of sale dated 1967. It is seen that the said document is of a value of rupees 500. Considering the above, in view of section 17 and section 49 of the Registration Act 1928, the property, the suit land, would not have been affected without their deed of sale dated 1967 being registered. This would also find it relevant to take note of that the learned First Appellate Court did not grant any declaration of right, title, and interest of the plaintiff over the suit land. What in effect it decreed, the learned First Appellate Court had decreed, the learned First Appellate Court had decreed is only that the plaintiff is in possession of the suit land. This point further finds it relevant to take note of the judgment relied upon by the learned First Appellate Court in the case of Bhumgar Singh and others, versus Nihal Singh and others, reported in 2003 4 SCC 161. wherein the Supreme Court dealt with Section 17 and the effect of an unstamped and unregistered sale deed. In the same judgment at paragraph number 5, the Supreme Court observed that a sale deed is required to be properly stamped and registered before it can convey title to the vendee. It was also observed that a document like the sale deed, which is an unstamped and unregistered, even though not admissible in evidence, can be looked into for the collateral purposes. In the same case, the collateral purpose which the Supreme Court duly took note of was the nature of possession of the plaintiff over the fruit land. In the instant case, it is seen that on the basis of the deed of sale dated 31-1967, which was an unregistered deed of sale, that there was possession was handed over only for the purpose of handing over of the possession by the plaintiff, by possession in favor of the plaintiff. The said deed of sale, unregistered deed of sale dated 31-1967 would have been taken note of. It is also relevant to take note of that the defendants, though have made high claims as regards their right, title, and interest over the suit land, as well as for being in possession, but there is no evidence adduced. It is a settled principle of law. The pleadings are not proof. Considering the above, it is the opinion of the court that the substantial question of law for claim is not involved in the instant appeal. Accordingly, this court does not find any merit in the instant proceedings or in the instant appeal for which the appeal stands dismissed. Before starting with the record, this court, however, finds it necessary to clarify that the decree which have been passed in favor of the plaintiff should only be construed as a decree acknowledging that the plaintiff is in possession of the suit land and nothing more. This is what because only we
And
so it will be only the recognizing that he will put it.
you pattern all the eyes and skills.
Yes, yes, this matter is urgent. Yes, Mr. Mohanta, what are you doing? What matter? Let us take your matter. You always seem to be reluctant when I take matter. Like 2005, my goodness. Need to finish it. It is a question of law. Whether the suit was maintainable in view of the fact that transportation is claimed with respect of a portion of gold of the land which is not exclusive possession of the vendor. What is it? I don't understand what is the matter.
Because for me also, I have to understand that time. If the big fact of the business, it is reverse and the defendant appellate. Because when the bill was so against that,
Others will go others. You are the defendant. You are the defendant.
sale is not covered. What if they have a agreement for sale? It's not the agreement for sale, my lord. The possession subsequent pay, my lord, register sale. Defendant he was there.
How can this be question of
My
law?
lord, that's why I'm discussing this, my lord.
He may have a recovery of transportation. He will ask. But if it is a joint purchase, then 34 will rule it. He will have a right of claim for partition. Rule it. It is the joint purchase.
Our defendant he was, my lord, as such point. And my lord, Thane trial court, my lord, Thane trial court says that, my lord, since, my lord, after the practical sale, never been possessed this land, because this land was possessed by the defendant long back in 35 years ago. Before the shipment. 35 years ago, before the shipment. So that's why, because although, there is a very, very interesting point. Here, my lord, it was this, also, my lord, might know that the transportation also did. It has not taken into consideration. So, my lord, only by the plaintiff to file an appeal. And if it was allowed, that my lord, section 54, sale. Because the trial court, my lord, is a finding that plaintiff has, my lord, although the possession has nothing to do, because he has not, he never did possess the land before passing. And that point, my lord, it was allowed.
Possession and requisite. Is possession required?
Respect of sale, my lord. So, my lord, possession is not important.
What is required is only in gift.
If can, my lord, in Norwegian law, it is required, my lord, sale is not complete. It is not complete, yes, can. In gift, my lord, possession,
No, not only that. A gift have to be accepted
yes,
under 121.
and delivery of. So that is
There
the,
might
that
be
is
a
the
question
ingredient.
out there, but still,
Not here, my lord, nothing. That I have seen, my lord, last night, my lord, I have searching, my lord, whether it is, my lord.
I have delivered one judgment of the question of in 54, there is nothing. A sale
Possession
can
is
happen,
nothing.
and after the sale, he can very well ask for whatever it is.
My lord,
Now, what is explained? Let us see,
same, my lord, that same.
where is the judgment of the first appeal?
Husband of the first of the court, my lord, has been on. Page 8, my lord.
Clearly, right that clearly is entitled to recover vacant possession of the system after eviction of the respondent thereof. Then, so why is that joint patta question coming into the picture?
But that surely, my lord, is there. My lord, they are he that into percentage not only to skip them, their land. And there's entire land belongs to the performer defendant, my lord, the person.
Nothing in me. So your substantial question of
My lord, that's why, my lord, I'm not satisfied with the certificate. I'm very clearly, I'm satisfied.
what is your substantial question? I hope you are not asking my view.
No, he states like that.
So what do you want, that I should put her name? So I'll say, I'm dismissing the appeal, and you are saying about Thursday. I'm only counting 10 minutes between the Uber for taking. You are paying for whom? You are
the main respondent.
1, 2, and 1 to 5. Defendant. You are. You have filed appeal.
No, appeal, because this week, then they file appeal.
Yes,
Here I second file by.
1 to 5. You purchased the supplement from where? So you did not file a objection.
So that wasn't any kind of very.
It is a bit possible. 1 days and next Thursday, next month, Tuesday, prepare with 1 lakh. Don't forget. People, no, people, nothing. I think we can. So many litigation. It costs 1 lakh. So you may now don't come here. So you go to the procedure. In my passage, are the judge for the last how many years? 4 years. He has come 5 times in that.
Give them.